Okay guys, so I think I am audible now. Sorry for the inconvenience, but probably I believe I'm audible. So I think I am audible now. Yes guys, sorry okay. For the inconvenience. So I think now I'm audible. Fine. I can hear my voice here in my system. Can you all give me the confirmation please if I'm audible to all of you as well? Just please let me know in the comment section guys. Quick and fast please. That will be really helpful. Come on guys, waiting for your confirmation. No one is here to comment? Probably I believe I'm audible. Okay, so here. So we are going to start, right? So first of all, very warm welcome to all of you to StudyIQ English, and very good afternoon as well. So let's begin the session. Sorry for the inconvenience as there was a bit problem with the audio setup, right? But now it's clear. So starting the topic, that is the constitutional bodies, right? So today we'll be discussing about some distinct chapters, starting with the constitutional bodies. Moving to the next chapter, that will be the panchayats and municipalities, and yes, the center-state relations along with the Indian judiciary. So these are the topics for the day. Okay. Indo-British Administrative Service. Indo-British Administrative Service, as in you are talking about the foreign services and you want to get posted inside the country of Britain, right? So probably I can understand this from your comment, dear Chahat Prem, right? Okay, but yeah, your dream, it shall come true very soon, and we from the StudyIQ English shall be, here with you and at the best to provide you the best, okay, of the content that is needed for you to fulfill your dream, accomplish your dream, right? Okay, so here we go guys, starting with the first topic here we have, that is the constitutional bodies. Okay, so first and foremost, how am I going to justify the term that is constitutional bodies? How am I defining it? Okay, what are basically constitutional bodies? Okay, is there any specific definition to it? Is there any specific meaning to it? So yes, okay, remember these are the two different things, constitutional bodies as well as non-constitutional bodies. Okay, so you must understand the difference. Okay, on one side we have got the constitutional bodies, and on the other we have got the non-constitutional bodies. Okay, so what is the difference between them? Constitutional bodies are simply those bodies, obviously, which are mentioned in the Constitution. Okay, and they derive their powers and functions from Constitution itself. Simply speaking, no statute is needed for their functioning. Okay, this is what generally the definition of the constitutional bodies. What are non-constitutional bodies? On the parallel side, okay, they are not mentioned in the Constitution, first of all. That is basically mean they require a separate statute, a separate statute or enactment for their existence. Okay, they are also known as extra constitutional bodies. Okay, so what they are known as? Extra constitutional bodies. Okay, they do not require any further statute. Okay, these are the constitutional bodies, and those who require, these are the non-constitutional bodies. Okay, also termed as what? Extra constitutional bodies, right? Okay, so when we talk about the factors of the constitutional bodies, so the first one that we are going to discuss here is the Election Commission of India. What do we have got in the picture? The Election Commission of India. Okay. It is a type of a body, okay, not type of a, actually a body that is considered the guardian of democracy in any particular country. Not just in India, in any particular country. Okay, when you are asked to mention about the guardian of democracy, okay, so it will be none other than the Election Commission of that particular country. For India, it is Election Commission of India. What is the existence, the basis of the existence of democracy? Okay, it is the popular government. Okay, the popular government, basically a government that is elected by the people, elected by the people themselves. Now, elected, whose responsibility it is to go ahead with free and fair elections. So it will be the Election Commission. Just talking about the free and fair elections, so it will be the Election Commission. To any democracy, okay, this is considered as the soul of democracy. Without this, there can exist no democracy at all. Right? Okay. So from the context of India, what we have got the Election Commission of India. Okay. So it is mentioned under Article 324. The first thing that you need to mark, under Article 324. So it is an autonomous constitutional authority responsible for administering union as well as state election processes. Okay, so one thing that we need to mark, the elections that are conducted by the Election Commission of India. Okay, what are these elections? Okay, that basically is conducted by the Election Commission of India. So it is the elections to the Lok Sabha, Rajya Sabha, State Legislative Assembly, State Legislative Council in case it exists, and the elections of President, elections of Vice President. Okay, so basically for the MPs, for MLAs, for MLCs, the President and the Vice President. Okay, which Election Commission of India is not going ahead with? Okay, which is not conducting. What are the types of elections that is Election Commission of India is not conducting? Okay, so it is the elections of panchayats and municipalities. right? So it is what? The elections of panchayats and municipalities only, for which a separate state election commission exists. Okay. Guys, do not get confused that State Election Commission will be the nodal agency for the state assembly elections as well. No, absolutely not. Okay. State assembly elections, they are also conducted or concluded by the Central Election Commission or the Union Election Commission only. Okay, it has nothing to deal with that the state assembly elections or council elections, they will be conducted by this state election commission only. Absolutely not like that. Okay, state assembly elections, assembly council elections, or the legislative council elections, okay, they are all concluded and conducted by the Union Election Commission only. That is the Election Commission of India only. Okay, just for the sake of the elections of panchayats and municipalities, we have got a separate commission that is known as State Election Commission. Okay, so I hope this is clear. Okay, next. So as you can see, the further of the features what we have, part 15. Okay, in part 15 of the Constitution, from articles 324 to 329, okay, it deals with the elections and establishes a commission for these matters. Okay, article 324, that talks about the superintendence, direction and control of elections to be vested in the election commission. Okay, then article 325, no person to be ineligible for inclusion or to claim to be included in a special electoral or roll on grounds of religion, race, caste, etc. That is, everyone is equal in the eyes of law, as we discussed in the fundamental rights segment, article 14, and everyone will be given equal opportunity to contest the elections as well as vote in the elections. Okay, so these are what? The constitutional provisions for the elections, right? As you can see here, the next one, article 326, what it says: elections to the House of the People and to the legislative assemblies of the states to be based on the adult suffrage. What is this adult suffrage concept? Adult suffrage as in a particular eligibility criteria is there for you to become a voter. Obviously, the first thing is you need to be the citizen of India. There is no question in that. Okay, first and foremost, what you need to be the citizen of India. Secondly, okay, you need to have at least 18 years of age to be conducted or to be seen as a proper eligible voter. Regardless of your age, okay, there is no other eligibility criteria to be a particular voter. Okay, no specific religion, community, race, gender, caste, etc., place of birth, place of residence, nothing. Okay, you just need what? You need to be two things. Firstly, obviously, the citizen of India. Secondly, obviously, you need to be at least 18 years of age. This thing was actually changed in the year 1989 through the 61st Constitutional Amendment Act. Okay, see, you can just note it down like this. Before 1989, the voting age, that is minimum, it used to be 21. But with the 61st Constitutional Amendment Act of 1989, it was reduced to 18. Okay, so from 21, it was now 18. Okay, so remember, till 1989, the voting age used to be 21. But with the 61st Constitutional Amendment Act, the voting age was reduced to 18 years. Okay, so now if you are citizen of India, 18 years of age, you can vote, doesn't matter, whatever your religion, community, etc. is, doesn't matter. Okay, So next we have got Article 327. Okay, what it is saying: power of Parliament to make provisions with respect to elections to the legislatures. Okay, simply speaking, the election conditions, okay, the election procedure actually, it is looked after by, or the watchdog is the Election Commission of India only. But the procedure of elections, let's say for example, the elections should be taking place with the ballot box system, or literally with the this EVM system. Okay, all of these things are to be taken care by whom? All of these things are to be taken care by the Parliament, that is the legislature itself. Next, Article 328, power of legislature of a state to make provisions with respect to the elections to such legislature, that is the panchayats and municipalities. And lastly, Article 329, bar to interference by courts in the election matters. Okay, the courts, they are not entitled, neither the Supreme Court, neither the High Courts, neither the subordinate courts or whatsoever, they are not entitled to interfere in the election matters. Only after the elections have been concluded, the final results have been out, only after that, if there is any anomalies or discrepancies, then only the judiciary can step in. But in the process of elections, judiciary cannot interfere. It is absolutely the role of the Election Commission of India, and Election Commission of India is fair enough as well as the competent authority to take care of it. Right? Okay, so this is what is mentioned under the Constitution, Part 15, from Articles 324 to 329. Okay, so Election Commission, next thing. Originally, the membership, when we talk about the membership of the commission, so as what we can see, what is mentioned, originally the commission had only one election commissioner. Okay, originally it was a single member body. Okay, there used to be one election commissioner. Okay, but after the Election Commissioners Amendment Act of 1989, it was made a multi-member body. Okay, so as of now, the Election Commission consists of one CEC, that is Chief Election Commissioner, and such number of other election commissioners, okay, as the President may from time to time determine. Okay, so understanding the difference here, let's understand the basic difference. What is written? Till 1989, okay, till what? Till 1989, Election Commission used to be a single member body. Okay, till exactly the time period 1989. But post 1989, with the Election Commissioners Amendment Act, it was made a multi-member body, that is one Chief Election Commissioner and such other election commissioners as the numbers may be determined by the President itself. Okay, so this is what the basic difference we need to understand. Now, the numbers of other election commissioners, they are not fixed. It is left into the hands of the President, as the President may time to time determine. Okay, so presently, as of now, it consists of one Chief Election Commissioner, it would be just one always, and two other election commissioners. Okay, remember, and at the state level, Election Commission is helped by Chief Electoral Officers. Okay, in all the states we have got CEO, Chief Electoral Officers, right? So what you need to mark? Before 1989, okay, before 1989, the Election Commission of India used to be a single member body. A single member body. That is one Chief Election Commissioner. But with the Election Commissioners Amendment Act, that is through the virtue of the 61st Constitutional Amendment Act. Okay. Now, what is mentioned? After 1989, Here there will be one Chief Election Commissioner and other election commissioners. And what will be the numbers? Okay, how many numbers? Other means how many? 1, 2, 3. Okay, how many? So it will be determined by whom? By only, okay, by only the Honorable President of India, right? So as of now, presently, what do we have? One Chief Election Commissioner and two other election commissioners. Okay, so presently it is a 3-member body. As of now, presently it is a 3-member body, right? Okay. Next, the president appoints, okay, CEC and others, okay. And now one thing that is to be marked on a very recent thing, it is the president appoints the chief election commissioner and other election commissioners as per the CEC and others appointment conditions of service and terms of office Act 2023. Other one has been here, okay, that is the very recent amendment to that is 2023, okay. Now, what it has been fixed? They have been given a fixed tenure of 6 years or up to the age of 65 years, whichever is earlier. Okay, and the salaries and conditions of the service of the CEC, okay, and EECs will be equivalent to the judge of the Supreme Court. Okay, so the next thing that we need to mark, what is that? Salaries and allowances. Salaries and allowances of the election commissioners and the chief election commissioner will be equivalent to a judge of Supreme Court of India. Okay, this will be the salary. Let's say, for example, a Supreme Court judge receives a salary of ₹100 plus allowance of, let's say, ₹10. So the very same way, the ECs plus the CEC will receive, that is ₹100 as salary plus ₹10 as allowance. For example, obviously it is not 100 and 110, okay, just for the sake of instance you can mark, okay. That is ₹100 if a Supreme Court judge is receiving as salary, so will the Chief Election Commissioner will also, okay. Now, next thing. The removal procedure. Removal procedure is as same as a judge of the Supreme Court. Remember guys, the removal procedure is equivalent, exactly equivalent to that of a judge of the Supreme Court. Now, what is the removal procedure exactly? Okay, what is the removal procedure? So, let's understand the removal procedure very carefully. First and foremost, okay, first and foremost, the grounds. What are the grounds? So, first ground is proved misbehavior, and second one is incapacity. Incapacity as in any sort of physical or mental illness. Okay, first is the proved misbehavior and second one is any sort of physical or mental illness. Okay, now let's say, for example, there is this is common for the judge, of Supreme Court plus High Courts plus the Chief Election Commissioner plus the CAG. Okay, remember everyone, the grounds what we are discussing, grounds of removal or the removal procedure, it is common. Common for whom? Common for the CAG, common for the Chief Election Commissioner. Remember, we are dealing with the Chief Election Commissioner only. CEC only and not the other election commissioners, as they hold office kind of on the pleasure of the president. Okay, they can be removed by the president only on the recommendations of the CEC, that is the Chief Election Commissioner. Okay, so remember this thing. Now coming to the point, the removal procedure, okay, whether this is the judge of a Supreme Court or a High Court, whether it is the Chief Election Commissioner, whether it is the CAG, that is the Comptroller and Auditor General of India. Okay, so whatsoever the person is, the removal ground is same. So now let's say any of them is said to be removed. So firstly, a removal proposal, shall be initiated. Initiated where? Okay, it should be in either house of Union Parliament only, not in the state legislative assemblies or councils. Okay, Union Parliament only. Let's say, for example, if it initiates in Lok Sabha, then it needs the support of at least 50 members, sorry, 100 members. Okay, at least how many members? 100 members. In case it initiates from Rajya Sabha, in case, okay, it can initiate from either house. So let's say it initiates from Rajya Sabha, so it needs the support of at least 50 members. Okay, now if it is signed by 150 members both, then what will happen? The very next procedure, then it will be given in case of Lok Sabha to the Speaker, and in case of Rajya Sabha to chairperson. Speaker may accept or may reject. Speaker has got absolute discretion over this. Okay, same goes with chairperson, may accept or may reject. Okay, so they have got absolute discretion over this. Okay, they may accept or they may reject as well, right? So remember, they have got absolute discretion over this point. Let's say they have rejected. Okay, let's say what? They have rejected this proposal, that no, okay, I am rejecting it. So in case they reject, the resolution automatically ends. Immediately it ends. No further discussion, no further, delegation, deliberation, etc., will take place. Nothing. If the speaker or chairperson rejects, that means it is done. But let's twist the story here. Okay, in case, okay, in case they accept, okay, let's say they said, okay, I am accepting the resolution, right? They have accepted the resolution. Then what will happen? Then the motion, resolution, once accepted, then it will be converted into motion, okay, that is the removal motion. And once accepted, okay, the removal proposal, if accepted by the presiding officer of the House, by the presiding officer of the House, then it converts into removal motion that needs to be passed with special majority from both the houses of Parliament. From both the houses of Parliament, that is Lok Sabha and Rajya Sabha. Okay? If accepted, only the condition is if accepted. Right? Now, 2/3 of the majority. Okay? Special majority as in, okay, what? 2/3 special majority as in a majority of not less than 2/3 of members present and voting. Okay, this is what the meaning of special majority is, right? So if it is accepted, let's say it is initiated in Lok Sabha, so 100 members, they have signed the proposal. It is given to the presiding officer, that is the speaker, and speaker accepts the removal proposal. Then, firstly, from Lok Sabha, special majority, then it shall move to Rajya Sabha, and then it shall pass from there with special majority, and then it shall go to the president. And when president signs the removal motion, okay, the judge of the Supreme Court or the High Court or the CAG or the Chief Election Commissioner, that is whomsoever, okay, for resolution, the removal resolution has been initiated, will set to be removed. But there is a twist, there is a catch in between. Okay, what is the twist or the catch? In the meantime, let's say in the meantime, removal proposal has been accepted and the first house, okay, whatsoever is Lok Sabha, Rajya Sabha, has, started the motion, okay, passing the motion as well. Then in between, okay, in between, when the motion is being passed, when the motion is being passed, another side story will take place. Okay, what? That will be an inquiry committee. Okay, what? An inquiry committee. Okay. The inquiry committee shall consist of the following, that is, the Chief Justice of India, Chief Justice of any High Court, and a distinguished jurist from any side, from any court or what. Okay? So, basically, it is majority of the time a Supreme Court judge only. Okay? So, once the removal motion has been accepted, okay, once the removal motion has been accepted, then before it passes from the Parliament, inquiry committee consisting of these three people shall conduct the inquiry, okay, that has been, the inquiry that is about the charges that has been posed over the aforesaid judge, CAG, CEC, okay. In case, see the power of this inquiry committee, okay, understand the power of this inquiry committee. In case this inquiry committee finds that the charges framed on the person, judge, CAG, CEC, CAG, whatsoever, okay, is not correct, let's say the inquiry committee in its investigation, it finds out that the charges framed on the judge or the CAG, CEC or whatsoever is not correct. They are false, malified. Then the removal motion, even if it is passed by both the houses, shall end immediately. Okay, even if it is being passed by both the houses of the parliament, then it shall end immediately. This is the power of this inquiry committee. Okay, so guys, you need to mark what? The power of the inquiry committee. Posing CJI, Chief Justice of a High Court and a judge of the Supreme Court, right? If this committee recommends that no, the charges framed are not correct, malified grounds, then the removal procedure cease to exist immediately. Okay, on a very immediate note. I hope this is clear with the Election Commission, right? Now the next feature for the Election Commission. The Constitution has not prescribed, literally, the Constitution has not prescribed the qualifications, that is their legal age, minimum age, educational, administrative or judicial experiences. Okay, no such minimum to maximum qualification has been prescribed by the Constitution. Okay, the Constitution has not specified the term of the members of the Election Commission. Only the CEC, that is 6 years or 65 years, not the others. Okay, and neither the Constitution has not debarred the retiring election commissioners from any further appointment by the government. Okay, so once the CEC or other election commissioners, they are being retired, okay, or their tenure has ended, so Constitution has even not barred them, okay, from having any further government position, okay, government or the constitutional position even, right? Okay, guys, please, I would like to quote here one basic thing. There is huge difference between government position and constitutional position. Okay, like for example, the AG, CAG, CEC, what they are not the government positions. Okay, they are what? They are the constitutional bodies. That means the constitutional positions they are. Remember, okay, they are literally not the government bodies. They are the constitutional bodies, including the Supreme Court, High Court judges. Okay, what they are the constitutional positions or the constitutional bodies. Remember this thing, right? So when we talk about the this qualifications, experience, okay, about the terms and conditions of the office for the election commissions, okay, election commissioners, Constitution has kept itself mute over all of these points. Okay, Constitution is literally mute over all of these points. Then we have to discuss a case study as well. Okay, that is here in front of us. What is that case study now? As you can see, the name of the case is Anup Baranwal versus Union of India case. Very freshly it took place in the year 2023. What is the case all about? A 5-judge bench of the Supreme Court unanimously ruled that appointment of the Chief Election Commissioner and the election commissioners shall be made by the President on the advice of a committee. Okay, the name of the committee or the members of the committee, they shall be the Prime Minister of India, the leader of opposition of Lok Sabha only. Remember guys, in the previous marathon class, while we were discussing the chapter of Parliament, we discussed that there are two leaders of opposition. One is in the Lok Sabha and other one is in the Rajya Sabha. Right? So here we are dealing with the leader of opposition in Lok Sabha only and not Rajya Sabha. Okay, and we have got the Chief Justice of India as well. Okay, so remember the CEC along with the other election commissioners. Okay, appointment of Chief Election Commissioner and other election commissioners shall be done by whom? Okay, shall be done by President on the recommendation of a committee comprising of firstly the Prime Minister of India, secondly leader of opposition. Where? In Rajya Sabha? No, in Lok Sabha only. And then third, the Chief Justice of India. Okay, the Chief Justice of India. So presently, okay, the Chief Election Commissioner would have been, जो भी हमारे present Chief Election Commissioner हैं, okay, the present CEC would have been appointed by whom? It would be by Prime Minister, that is who? Narendra Modi, right? Then leader of opposition in Lok Sabha, who is he? It is Rahul Gandhi. And the Chief Justice of India, that is presently Sanjeev Khanna. Right. So the present CEC, as per the Anup Baranwal versus Union of India case 2023, would be appointed by the following three people. Okay, and let's say sometimes it might happen that there is no leader of opposition. Okay, so let's say for example, in case, okay, there is no leader of opposition is available in the Lok Sabha, then it shall be the leader of the largest opposition party in the Lok Sabha in terms of numerical strength. Okay, let's say to become a leader of Lok Sabha, or sorry, the leader of opposition in Lok Sabha, what do you need? A party needs minimum 10% of seats. Okay, minimum 10% of seats. Okay, inside Lok Sabha. Let's say 545, it is the maximum strength. So 10% as in 54.5, that is 55. So whichever party is presently having the minimum strength, that is 10%. Okay, will be the leader of the that party will provide the leader of opposition in the Lok Sabha, and so as well as the Rajya Sabha. But it might happen that no party possess that 10% mark. Okay, then let's say the other party, whichever is having below 10%, near to 10%, that is 9%, 8%, 7%, whatsoever. Okay, from that it will be chosen. Okay, that is the single largest party in the opposition. Its leader will be there into the committee. okay, as it has happened in the 2019 elections case. There was no party which was having 10% of seats, okay. So at that time, it was that the party with highest number of seats, that is below 10%, okay, was considered as the opposition, right, okay. So the Parliament passed the Chief Election Commissioner and other election commissioners appointment conditions of service act 2023, okay, in response to the Anup Baranwal versus Union of India case 2023. So remember guys, presently how will be the whoso all will be the members. So it will be the Prime Minister of India, then leader of opposition in the Lok Sabha, and yes, it will be the Chief Justice of India, right? So all of you are able to understand till here, I think. So here we go to the next body, that is the Public Service Commissions, the UPSC, SPSC and so on, okay. Now the thing here that is in front of us, as per Article 312, as per what? Article 312 of the Indian Constitution, the Parliament is entitled to create one or more All India services, including All India Judicial Services. Okay? Remember, as per what? Your IAS, IPS, judicial services, they are empowered through which article number of the Constitution? Okay, it is through Article 312. Okay, Parliament, who is authorized? The Parliament, okay, is authorized to create one or more All India or the All India Judicial Services, which shall be common to the Union as well as states. Okay, so the recruitment to all these services are made by whom? By UPSC, okay, that is Union Public Service Commission. For administrative services at the state level, we have got the SPSC, that is the State Public Service Commission. Okay, next thing. Here we go. The UPSC is the central recruiting agency. It is an independent constitutional body. Remember guys, UPSC, you cannot consider it as simply the government agency. It is what? The constitutional body. Remember, there is difference between being a government body or being a constitutional body. There are basic differences, huge differences as in. Okay. You work as an IAS, IPS officer. You are a government servant. Okay, but you are UPSC, you are not government servant. You are one of the central nervous system, part of the central nervous system. Not the direct nervous system, but yes, the peripheral nervous system you are when you are a UPSC or SPSC, that is any constitutional body. Right? Okay. So the provisions for UPSC and SPSC, they are, the article numbers, remember, for UPSC and SPSC, they remain the same. We do not have separate articles for state public service commissions or like that. We have mentioned it under one part, okay, that is part 14 of the Indian Constitution, okay, that is from articles 315 onwards to 323. Okay, it deals with the UPSC at the center and SPSCs at the states. Okay, so the provisions regarding the composition of SPSC, appointment and removal of its members and powers and functions, they are same, as you can see, 315 to 323. Okay, no difference. They both remains same, that is common. Here we go. So as per the constitutional provisions, okay, as per the article numbers, simply what we have, as we can see. Firstly, Article 315. Okay, firstly what we have got, Article 315. That talks about the constitution of public service commissions, that is UPSC as well as SPSC. Okay, constitution as in how they are made, okay, what are their provisions and so on. 316, appointment and terms of the office of members of UPSC and SPSC. Okay, how they will be appointed, who will be the deciding authority, and so on. Okay. Next, Article 317, the removal and suspension of the member of UPSC or SPSC. Then Article 318, power to make regulations for the conditions of the service of the staff. Article 319, see here, the Constitution itself talking about the prohibition of holding the office by the members of the commission upon ceasing to be such members. Okay, so once you have held the constitutional position of UPSC or SPSC, you cannot hold any other government positions. Okay, yep. They are not part 15. Okay, make it clear, it is part 14. Right? Part 15 is the election commission. Okay, right? It is part 14, not 15. So next, what we have got? Article 320 states the functions of the Public Service Commission. 321, power to extend the functions. 322, expenses of the Public Service Commission. It is obviously charged on the Consolidated Fund of India. That means it cannot be made a subject to vote in the Parliament. Then 323, reports of the Public Service Commissions. Okay. So it is given to the Honorable President of India only, right? Report of the PSCs, that is the UPSC as well as the SPSC. 322, their expenses. 321, the extension of their powers. 320, that is exactly their functions. 319, the prohibition of the office bearers post-retirement. 318, power to make regulations for the condition of service of its staff, of its members and staffs. 317, the removal and suspension of the members. 316, the appointment and terms of office. And 315, the establishment and the proper functioning of the the Public Service Commissions. Remember, article numbers for UPSC, SPSC, it is both same. Okay, there is no separate article numbers for UPSC and SPSC. They both are same under one head from articles 315 to 323. Okay, so as we can see, the features, that is appointment and reappointment. How do we differentiate between reappointment and barring of appointment? Okay. So firstly, about the appointment of the members. The chairperson and other members of UPSC, they are appointed by the President of India. The difference is here, okay, just one difference that we need to mark. The chairperson plus other members of UPSC only are appointed by President. But a bit of the twist is here, though article numbers remain same. The chairperson plus other members of SPSC, State Public Service Commissions, are appointed by governors of the states only. Governors of the states only. Here, for UPSC, it is the President of India only. For SPSC, it is the governors of the concerned states only. Let's say the Public Service Commission, the State Public Service Commission of Maharashtra, the members, they are appointed by the governor of Maharashtra. The chairperson is also appointed by the governor of Maharashtra. But now, the catch, the twist again. The removal of chairperson or other members of UPSC or any SPSC will be done by President only. President of India only. So what is the difference? Though the SPSC members and chairpersons, they are appointed by the governors, okay, of the states concerned, but their removal is done by the Honorable President of India only, right? So I hope the difference you have marked, the difference is clear and there will be existing, no doubt. Okay, here we go. Next. So we have already discussed, okay, about the removal procedure. Okay, so as you can see, here is the difference. The removal or suspension of the members, the chairperson or any other members of the UPSC shall only be removed from his or her office by the order of the President of India. The President can suspend the chairperson or any other member from his or her office in respect of whom a reference has been made to the Supreme Court. Okay, and further, the conditions of removal. Okay, what are the conditions of removal or the grounds of removal? So what are they? Firstly, if a person is adjudged as insolvent, in Hindi we call it as diwaliya ho jana. Okay, that is bankrupt. Insolvent as in bankrupt. Next, engages during his or her term of office in any paid employment outside the duties of his or her office, that is, simply speaking, having any office of profit, having any other office of profit inside the government. You can have your private business, but not inside the government. Then lastly, is in the opinion of the President unfit to continue the office by a reason of infirmity of mind or body, that is any kind of the physical or mental illness. Okay, so what are the things, okay, that we need to mark? Firstly, is bankrupt. Secondly, having any office of profit. Thirdly, in the opinion of the President, the concerned person, okay, has been declared as mentally or physically unfit. Okay, this is what simply the grounds of removal they are. Okay, so as you can understand, the re-eligibility or the eligibility, what is written? The chairperson, just talking about the chairperson of the UPSC, shall be ineligible. Literally what? Ineligible for any further employment, either under Government of India or under any state government. But if there is a chairperson of SPSC, he or she will have just one further appointment, that is, they can become either the member or the chairperson of UPSC. Okay, so what is the difference? Okay, let's say here is a person who is either the chairperson or the member. Once retired, not eligible for any position in union or state governments. Okay, here SPSC, State Public Service Commission. Okay, either chairperson or any other member. Once retired, only eligible for, once retired, only eligible for appointment in UPSC either as a member or chairperson. Okay, so this is what they are eligible of. Right? Okay, that's it. If a UPSC member or chairperson has retired, that means it's all done now. No further government position can be given. Okay, a constitutional position can be given further, but yeah, no any government. But yeah, talking about the SPSC persons or the members, only one thing is available, and what is that? That is providing the membership or chairpersonship into the UPSC. Okay, that's it. So, next thing. JPSC. Apart from UPSC, apart from SPSC, okay, we have got the Joint Public Service Commission as well. Sir, if chairperson of the UPSC or SPSC declares resignation, to whom to the chairperson submit their resignation? They are to the President of India only. Okay, all the constitutional authorities, okay, or any such type of a bigger authorities we talk about, they submit their resignation only to the President of India only. Okay, right? President is the boss of all the bosses there. Right? So here we go. You might have or might not even heard, but they do exist. Okay, not everywhere, not all the time, but they can. They are termed as JPSC, Joint Public Service Commission. Okay, as per Article 315 only, okay, 2 or more states may agree that there shall be one Public Service Commission for that group of states. Group of states as in minimum 2. Maximum, there could be anything that is not defined. Okay, there could be as much as it is not defined. So, the resolution to such an agreement shall be passed by each house of the legislature of the state. And only then the Parliament may by law provide for the appointment of the Joint State Public Service Commission. Okay, so remember the procedure. If there are 2 states, 2, 3, 4, 5 states whatsoever, and they have passed a resolution that they want to create a Joint Public Service Commission for themselves. Okay, so in that case, firstly, such a resolution shall be passed by concerned states, their state legislature. Okay, let's say there are 2 states or 3 states whatsoever. So all those 2 or 3 states, they need to pass a resolution in their state legislative assemblies, and only when they have passed a resolution to establish such Joint Public Service Commission, then it will be given to the Parliament, and Parliament will have to create a statute which shall be, having the assent of the President as well. Then only the states, they are authorized to create such Joint Public Service Commission. Okay, so what is the simple procedure? Let's say there are 2 states, state X and Y. So they have decided that they will create a joint public service commission for themselves along with their existing SPSC. Okay, their SPSC is there, it is not dissolved. Just apart from SPSC, they are also willing to have JPSC. That is the Joint Public Service Commission. So firstly, state X need to pass a resolution from its assembly along with state Y as well. Okay, so state X and Y, they will pass a resolution in their respective legislative assemblies. Then it will be now sent to the Parliament, and Parliament will have to create a statute, a law for the type of the JPSC. Okay, that shall have the president's signature as well, and then only those two states will be allowed to establish their own joint public service commission. It's not like that the states, they have themselves decided and they can establish JPSC. Absolutely not like that. They need the recommendation or the enactment from the Parliament only. They cannot enact by themselves. Okay, right? So this is about JPSC, Joint Public Service Commission. Okay. So here we go. That is the Finance Commission. This we discussed in the previous session as well. So, okay, about the Finance Commission Article 280. We didn't discuss the Election Commission and the UPSC and JPSC and SPSC in the last session, but we discussed about the Finance Commission in the last marathon. Okay, so we can go ahead. So these are the things: National Commission for Scheduled Caste, Scheduled Tribes. Okay, we discussed it in the previous session only. Okay, what we didn't discuss was the National Commission for the backward classes. Okay, but still we need to figure out a few of the things that is very important for us to discuss as well. Though we discussed in the previous Sunday's marathon only, but we will discuss it today as well. Okay, that is National Commission for Scheduled Castes and Scheduled Tribes. Okay, what is that? National Commission for Scheduled Castes and Tribes. Okay, so firstly we are dealing with National Commission for Scheduled Castes only. It is dealt under Article 338. Okay, that is NCSC, National Commission for Scheduled Castes. Okay, so as we can see the differences here. Okay, so we have it here. What are the key features that you need to mark? Okay, remember, what are the key features that you need to mark? Initially, the Constitution provided for the appointment of a special officer. It was not a commission. Special officer under Article 338 that shall be looking for the scheduled tribes as well as scheduled castes. Okay, but the 65th Constitutional Amendment Act of 1990, okay, what it created? It amended Article 338 of the Constitution and replaced the one-member body, okay, to a multi-member national commission. Okay, that was for scheduled castes as well as scheduled tribes. But through the 89th Constitutional Amendment Act of 2003, okay, the Scheduled Caste Commission and Scheduled Tribes Commission, they were bifurcated. Okay, guys, remember the difference. Okay, very, very important and very, very twisting in nature as well. Okay, see, before 1990, or simply you can mark before 65th Constitutional Amendment Act of 1990. Okay, there used to be a single member body. Okay, there used to be what? A single member organization, that is not even organization, it was considered as under Article 338. A special officer for the scheduled castes and the scheduled tribes. Okay, just one special officer for scheduled castes and scheduled tribes. Okay, that is till 1990, that is 65th Constitutional Amendment Act before. But, okay, but through the 65th Constitutional Amendment Act of 1990, this single officer body was converted to a multi-member National Commission. Okay, multi-member National Commission. And another catch here, there is another twist here. What is the twist? Till 2003, okay, till what time period? Till 2003, there was just one National Commission for both, that is SCs and STs. It was only through 89th Constitutional Amendment Act of 2003. Okay, it was only through this one, that is 89th Constitutional Amendment Act of 2003, that the body was bifurcated. That is, we have got 338 article, that is National Commission for Scheduled Castes. And then we have got another body as well, that is under Article 338 capital A, that is National Commission for Scheduled Tribes. Okay, so remember guys, the evolution of the National Commission. Initially till 1990, that is before 65th Constitutional Amendment Act, there used to be just one single officer. Okay, those who, the one who used to take care of the safeguards and upliftment of the scheduled castes as well as tribes. But okay, things have changed with the 65th Amendment Act. National Commission was created, National Commission for Scheduled Castes as well as Scheduled Tribes. And this commission was bifurcated, that is in the year 2003 through the 89th Constitutional Amendment Act. Okay, so guys, everyone, all those who are here live with me, please tell me you guys are able to understand whatever we have discussed yet. All clear, there is existing, no doubt. Any questions you need to ask? All of you? Come on, everyone, just please give me the comment. Even if there is no doubts, just please mention no doubt. Okay, you can just mention no doubt. Okay, or there is the doubt, then please do type the doubt as well. Yeah, just a short update I would like to give. What I have just received a message. That is, Indian Navy fires multiple anti-ship missiles in Arabian Sea near Pakistan. और कर लो अटैक तुम लोग, अब भुगतो, right? Pakistan tasting its own medicine, right? So Indian Navy, last time Indian Navy indulged in a war, it created a new country, Bangladesh, right? This time Indian Navy is super active. Just 48 hours back, DRDO successfully tested the hypersonic missile. Hypersonic, that is 5x the speed of sound. You know, just a value addition, let's discuss, okay, as we were having this discussion in yesterday's the Hindu analysis class, if you guys are present there. It is the achievement logged by DRDO, okay, by which organization? The very prestigious Defense Research Development Organization, DRDO, right? What they have done? They have successfully tested the hypersonic missiles. Hypersonic, you know what is the meaning of the word hypersonic? Hypersonic as in that is having a max speed between 5 to 10. Mach 1, that is the speed of sound. Mach 2 is 2x speed of sound. Or Mach 5 is 5x speed of sound. Okay, so hypersonic ranges between 5 to 10 Mach, as in the speed of sound in air, not in vacuum. Okay, remember, it is 343 meters per second. This is the speed of sound in air. Speed of sound in air. So this is 5 Mach. Okay, that is nearly 1710 meters per second. Okay, so a hypersonic missile has been successfully, okay, tested by whom? It is Defense Research Development Organization. Okay, and right now we have got the news. Indian Navy has what done? Has fired some missiles. Okay, how many of them? Though I didn't have the exact message here, but yes, multiple anti-ship missiles in Arabian Sea near Pakistan. Okay, आओ पहलगाम आओ, फिर बताते हैं. And what they have tagged, the wonderful thing that we must note here, okay, the tagging that has been done by Indian Navy while they gave us this news. Hashtag mission ready, hashtag anytime, anywhere, anyhow. Okay, this is what Indian Navy is doing. Hashtag mission ready, hashtag anytime, anywhere, anyhow. Okay, so last time when Indian Navy indulged in a war, okay, Bangladesh came into being. Signs are here. Indian Navy is all set. Okay, Rafale M. Today it is 28th of April, right? 27th of April. So by tomorrow, Rafale M will be finalized as well. Okay, Rafale M, that is Rafale Marine. 63,000 crore rupees we have invested, okay, to get the Rafale Marine version, okay, the Rafale Marine, that is Rafale M variant of Rafale, into the Indian Army, Indian Air Force basically, that can be successfully landed and taken off through the aircraft carrier vessels we have, specifically INS Vikramaditya and INS Vikrant. Okay, INS Vikramaditya presently nearly the Bay of Bengal region, and INS Vikrant nearly the Arabian Sea region. Okay, so we have successfully now test fired the hypersonic missiles. Indian Navy is firing the anti-ship missiles, and Rafale M coming soon, right? So what they gave the slogan always, Bharat tere tukde honge, what these Pakistanis and their agents across the borders as well as inside Pakistan, what they have always quoted, Bharat tere tukde honge, right? They have already given this threatening slogans always. So it's time for us, Pakistan tere tukde honge. Not a very far event thing, right? So the Army, the Navy, the Air Force, they are all getting ready. And specifically at the time, when, you know, the world is also against the Pakistan, including their very close brothers Iran and Afghanistan, right? तालिबानी खुद ही मार रहे हैं आजकल पाकिस्तानियों को, right? So नहीं करना था उनको ऐसा ना, अभी पहले ही पिस रहे हैं, इकोनॉमी डाउन है, अभी तो प्यासे भी मर रहे हैं, पानी आ रहा अचानक से छोड़ दिया झेलम का, अभी बह भी रहे हैं, राइट? ओके, नॉट अ बिग डील, सो नॉट अ बिग डील फॉर अस, राइट? पाकिस्तान समझेगा अपना, देख लेंगे, राइट? सो just the value addition, guys, wanted to share. I got the pop-up message. Okay, so coming here to the scheduled caste, National Commission for Scheduled Caste and the Scheduled Tribes. Okay, so remember, guys, one thing, it is a multi-member body. Okay, multi-member body as in how many members are present there. So it comprises of a chairperson, a vice chairperson, and 3 additional members. Okay, so National Commission for Scheduled Castes, how many total members? 5. Chairperson, vice chairperson, and 3 additional members. Okay, right? So the conditions of service, etc., they are also determined by whom? By the President of India only, and it is common, okay, for the Commission of Scheduled Caste as well as Scheduled Tribes. Okay, so multi-member body, obviously that is why the name Commission. 5 members in Scheduled Caste Commission as well as Scheduled Tribes Commission, that is a chairperson, a vice chairperson, and 3 distinct members. Okay, right? So we discussed this in the last class itself, and yes, through the 102nd Amendment Act, we have now got a separate commission as well, that is the Backward Classes Commission. Okay. Yeah, and one thing that we need to mark here, okay, very, very important. Okay, make a asterisk mark, a star point, whatever, and please do mark it. The members, whether it is of the National Commission for Scheduled Castes or maybe Scheduled Tribes whatsoever, okay, they hold their office for a term of 3 years only. Okay, for a tenure, for a term of how many years? 3 years only, right? And apart from that, they are eligible for reappointment only once. That means they can have their 2 tenures, 2 terms. Just like the US President, a person, an individual person, can hold the office of the US President for how many times? Not more than 2 times. Okay, it shall be not more than 2 times. So in that very same sense, okay, the members from chairperson to vice chairperson to other members from the National Commission for Scheduled Caste, Scheduled Tribes, or even the backward classes, they are eligible for reappointment only once. That means they can hold their office for 2 terms only, maybe consecutive or maybe not. Okay, but they are eligible to hold the office for only 2 terms. May be consecutive, may not be consecutive whatsoever. Okay, so this is what it is common for Scheduled Caste Commission, Scheduled Tribes Commission, as well as the Backward Classes Commission. And remember, before the year 2018, okay, before the year 2018, we didn't had any separate commission for backward classes. Okay, we didn't had any separate commission for backward classes, but through the 102nd Constitutional Amendment Act, we have got a separate commission for the backward classes, that is NCBC, National Commission for Backward Classes, under Article 338 capital A. And one value addition more. We have got a community in India, okay, that we call it as Anglo-Indian community. Anglo-Indian community. Anglo-Indian community means parent 1 is Indian and parent 2 is British. Okay, that is what is Anglo-Indian community known as. Okay, either of the parent is British and Indian. Okay, So when we just consider Anglo-Indian community, okay, just simply. So for them, we do not have any specific committee, any specific organization. Their safeguards, protections and so on, it is centered into the hands of National Commission for Scheduled Castes. National Commission for Scheduled Castes. Okay, that is under Article 338. Okay, what we have got, National Commission for Scheduled Castes, and they only take care about the safety measures, promotion, protection of the National Commission, the Anglo-Indian community. Okay, remember this thing. So 102nd Constitutional Amendment Act gave the existence of the National Commission for Backward Classes. And here, some information that we need to mark. Here we go. There were two backward classes commissions, okay, appointed during the 1950s and 60s. The first one was the Kaka Kelkar Committee and the other one was the BP Mandal Committee. Okay. Kaka Kelkar Commission, also known as the first commission of the backward classes. BP Mandal, also known as the second commission of backward classes. But remember, these were not constitutional positions. Okay, these were the governmental organizations only. Okay, simply the investigating agencies, right, for the situation, condition of the backward classes. Okay, so what are the two commissions' names? Kaka Kelkar and BP Mandal. Okay, these are the two commissions that you need to mark. Okay, so 2018 gave 102nd Constitutional Amendment Act, through which Article 338 capital B came into being. You can just note down the name of the article number. What is that? Article 338 capital B. That gave us what? That gave us the National Commission for Backward Classes. But it doesn't, it is not like that we do not had any other constitutional provisions for the backward classes. We had, for example, Article 340. What Article 340 basically explains us? So it deals with the need to inter alia identify those socially and educationally backward classes, understand the conditions and make recommendations for their upliftment and so on. Okay, and through the 102nd amendment we got one more article, that is Article 342 capital A. So remember guys, Article 342 capital A and Article 338 capital B, they both came into existence through the 102nd Constitutional Amendment Act. Okay, so Article 338 capital B, 342 capital A. And before the amendment we had the Article 340 that was not talking about any sort of the National Commission, but it was talking about to look into the conditions of the socially and educationally backward classes and identify, okay, their needs, identify their grievances and how to redress them respectfully. Okay, this is what the Constitution under Article 340 was mentioning, but it was not mentioning any sort of special commission, a special designated national commission constitutionally. But it came into existence 2018, 102nd Amendment Act. Okay, so when we talk about Article 342 capital A, what it is? It empowers the President. Okay, what it does? It empowers the President to specify socially and educationally backward classes in various states and union territories. Okay, just like through Article 342 and 341, President has the power to mark the scheduled castes and scheduled tribes throughout the country. Okay, 342 capital A marks the President's authority to provide the status of socially and educationally backward classes, that is simply the backward classes. Okay, so President can do so. Okay, she can do so, okay, in consultation with the governor of the concerned state. Let's say Honorable President Draupadi Murmu, she wants to declare any community as backward community inside the state of, let's say, Gujarat. So she can do so, but she has to take into consideration the advices of the governor of the state concerned. However, the advice shall not be binding on the President. Okay? Right. However, law enacted by Parliament will be required if the list of backward classes is to be amended. Okay, so if President wants any particular backward class, any particular community to be inducted in the backward class, okay, then President can do so. We'll have to take into consideration the advices of the governors of the state, but presidential order needs to be enacted by the Constitution, by the Parliament as well. Okay? Right, guys? You're all able to understand here? I hope so. Okay. Next one is the CAG, Comptroller and Auditor General of India. Right? We discussed CAG in the last session, but there were few things that we didn't have. Okay, so we are having it here. First and foremost, the historical background. Guardian of the public purse, right? Under which article? So we consider Article 148 as the authority or the existence of the CAG. But let's talk about the historical presence or the evolution of the office of CAG. Okay, so as you can see, Office of the Accountant General was established in the year 1858. Okay, that is after the proclamation of Queen Victoria, when India officially became the territory of British. Okay, and in 1860, Sir Edward Drummond, Edward Drummond became the first Auditor General of India. Okay, after restructuring, it happened in the 1866. The office was renamed as the Comptroller General of Accounts. Okay, and in 1884 it was redesignated as the Comptroller and Auditor General of India. So technically the position came into existence in 1860 as the Auditor and Accountant General to the Government of India. In 1866, it was redesignated as the Comptroller General of Accounts, and in 1884, it was finally redesignated as, which we are presently using as well, that is Comptroller and Auditor General of India. Right? So this is what basic features, okay, the evolution to the office of CAG is. Okay. Further, we have already discussed the other points, okay, that is the Guardian of the Public Purse, Article 148. Okay. Once again, we can have a short revision. Broadly deals with the CAG appointment, oath and conditions of service. 149 deals with the duties and powers of the CAG. 150 says the accounts of the union and the states shall be kept in such form as the President may advise, okay, to the CAG. And Article 151 says the report of the CAG, okay, relating to the union and the state accounts shall be laid in front of each house of the Parliament by the President only. Okay, the reports of CAG, okay, they are given to the President. Okay, and from there the President take these reports, these accounts, okay, to the Parliament. Okay, so Article 148, 49, 50 and 51 respectively all deals with the powers, functions, authorities of the CAG. Okay, so these are the things already discussed, right? So We discussed in the last session about the Attorney General of India as well. That was under Article 76. Okay, that is, who is Attorney General of India? The advocate of the government of India under Article 76, as well as we have got the advocate for the state governments as well, that is under Article 165. What is the difference? Okay, if it is the advocate of the central government, we consider the body as the Attorney General, but if it is the advocate of the state government, we consider the body as the Advocate General of India. Okay. Yes, we have got the Solicitor General as well as additional Solicitor Generals, but yeah, they are the non-constitutional bodies. Okay. So guys, this brings us to the end of the chapter, constitutional bodies, right? Okay. And we shall move to the next chapter here, that is the Panchayati Raj institutions. Okay, the next thing that we are about to discuss today, that is about the chapter Panchayati Raj institutions. Okay. Yes, dear, CAG Article 148 to 151. Yep. Under Part 5, that is chapter Part 5, chaptered as the Union. Okay. Fine, all of you. So let's take a short break. I don't know about you guys, but my throat needs some glass of water or a kind of a beverage as well, like a cup of a hot coffee, right? So guys, everyone, we shall take a break of around 15 minutes, right, before starting this chapter, that is Panchayati Raj institutions. Okay, so let's take a short break. Okay, and we shall resume the class after 15 minutes. So is it right now around 3:42 or something? Okay, so here it is, break. Okay, we shall resume the class. Three 4 p.m. correct. Okay. Okay, guys. So let's take a short break. Okay. The class will be streaming on live only here. We shall just take a short break, and everyone, we will be back by sharp 4 p.m. Okay. Break. Class resumes what time? Class resumes at 4 p.m. Okay, so it's a 15-minute short break. Let's go grab some water and be back. Okay, guys, see you soon. Okay guys, welcome back after the short break. So I hope every one of you are now kind of refreshed, right? So we are good to go with the next chapter into our list, that is Panchayati Raj institutions, right? Okay, so what are we going to discuss? That is the panchayats in India. How are they working? Why are they working? What are their constitutional provisions and so on? So to begin with, the chapter of the panchayats in India. It is the oldest form of government. Okay, what it is? It is the oldest form of the government. Yes, coming from not just the medieval ages, but also the British ages or the modern ages. It is from the ancient or even before ancient era. That is, when we talk about the epics of Mahabharat and Ramayana, what we have, they have also mentioned about the local self-governments, specifically the organization of the Gram Sabhas, the Panchayats in India. So remember guys, what's the most important thing here that we need to mark? That Panchayats in India, okay, they are not a new body. They are not an outcome of the modern governmental organizations or the processes, okay? They are there since the ancient civilizations, since you can call it the civilization term came into being. It came into being with the provisions or the elements of the local governments, specifically panchayats. So as we can go ahead, okay, first and foremost, how do I justify the term Panchayati Raj institution? Okay, PRIs. So it is a system of rural local self-government in India. What it is? A system of rural local self-government in India. Okay, local self-government, that is basically, it is the management of local affairs by such local bodies who have been elected by the local people. There is a term that we often take when we discuss the panchayat system in India. Okay, not in India, anywhere throughout the globe, that is the grassroots democracy. Okay, what is this? The grassroots democracy. It is a government given to the local people at their doorstep. Okay, what it is? It is a government given to local people at their doorstep, right? So whenever I have to mention grassroots democracy, I have got two bodies with me. I have got the PRIs, that is the Panchayati Raj institutions, and the other name, okay, that is ULBs, that is urban local bodies. Okay, I can call them as what? The Panchayati Raj institutions. Or I can also call them urban local bodies. Okay, so calling them as ULBs or PRIs, what they are the representation of the principle that is known as the grassroots democracy. Okay, so in India we have got two types of grassroots democratic organs, that is the ULBs as well as the panchayats. So when we talk about panchayats in India, as I stated, they are not a new government feature. They have been since the ages of the epics of Mahabharat and Ramayana. Okay, crossing through the time period of the ancient India, medieval as well as modern. just a year has been marked, what you can see on your screens, as 1992. Okay, we have just marked an year. What is that year? 1992. Okay, it was a landmark year. For the sake of what? Landmark year for the sake of what? When we provided the constitutional frame to the panchayats in India. Remember, it is not like that before 1992 in India we didn't had Panchayati Raj institutions. We had them. Okay, but the only difference is post 1992, by year 1992, we provided them the constitutional status. Before 1992, they were not constitutional in nature. But post 1992, they became what? The constitutional authority or a constitutional body. Okay, so here we go with the understanding of the thing, that is Panchayati Raj institutions. Okay, so evolution of PRIs. Okay, just talking about the evolution of PRIs. So as you can see, the first era what we have got, Vedic era. In the old Sanskrit scriptures, word Panchayatan has been mentioned. Okay, which means a group of 5 persons, including a spiritual man. That is a group of 5 people, out of which 4 people are normal political organized or the bodies. One person is there who is having the spiritual or the holy status. Okay, in the old Sanskrit scriptures, word Panchayatan has been mentioned. Okay, and this word Panchayatan means a group of 5 people. Out of these 5, 4 are the persons who are having the political position, whereas the other one, that is the 5th one, it will be a person who will be having a spiritual or a holy position. Okay, which gradually wiped away. Okay, gradually the concept of this spiritual man, okay, vanished. Okay, as you can see, it is mentioned here. Gradually this position of the spiritual man from the Panchayatan vanished. Specifically, when we talk about the book, that is Rig Veda, okay, there is a mention of Sabha, Samiti and Vidatha. It's not Vidatha, it is Vidatha. Okay, which book? Rig Veda. Rig Veda mentioned what? Rig Veda mentioned words, that is Sabha, Samiti and Vidatha as different type of local bodies or the local units. These were the democratic bodies at the local level. The king used to get the approval of these bodies regarding the certain functions and decisions related to the local area development or the local area administration. Okay, so what mentions Rig Veda? Sabha, Samiti and Vidatha. Please do not pronounce it as Vidatha. Okay, Vidatha will be different, that is we mention Almighty or the God with the word Vidatha. Okay, here Vidatha. Okay, it is a local unit in the ancient or the epic era, basically, specifically mentioning the word Rig Veda. Okay, then we have got the further evolutionary concept, the history of Panchayati Raj. Okay, when we just talk about the evolution concept. Okay, so as per Mahabharat, okay, as per the epic of Mahabharat, the villages, okay, they were grouped into 10, 20, 100 and 1000 villages. Okay, this is what Mahabharat has explained to us, that there used to be a unit or a group of villages. Okay, what was that? Group of villages having what? 10, 20, 100 and 1000 villages. Right. So the Gramik, simply speaking, was used to be the chief official of village. One village. The chief official of one village, that is Gramik. Then the chief of 10 villages as Dashap. Okay, the chief of 10 villages, what? Dashap. Okay. Then we got the chief of the other sort, that is Vinashya Adhipati. Okay, it was the chief of 20 villages. Okay, Vinashya Adhipati, chief of 20 villages. Then we got Shatgram Adhyaksha, that is chief of 100 villages. And we got the Shatgram Pati. He was the chief of 1000 villages. Okay, so remember guys, the features, okay, mentioned where? In the book, that is Mahabharat. Okay, what it has mentioned, that the groups, there used to be the groups of villages having 10 groups, 20 groups, 100 groups and 1000 groups. The one who used to lead the Sabha, Samiti or Vidatha of one village, okay, that is simply the chief of one village, was termed as Gramik. Okay, termed as what? Gramik. Chief of 20 villages, okay, or sorry, 10 villages, was considered as Dashap. Chief of 20 villages on the further side, okay, was considered as what? Shatgram, or sorry, Vinashya Adhipati. Then chief of 100 villages as Shatgram Adhyaksh, and chief of 1000 villages as Shatgram Pati. Okay, so Gramik 1, Dashap 10, Vinashya Adhipati 20, Shatgram Adhyaksh 100 and Shatgram Pati 1000. Okay, so guys, we need to mark this. I hope you are writing. So please write this thing as well. Chief of one village, Gramik. Okay, chief of one village, that is Gramik. Chief of 10 villages, okay, chief of 10 villages, that is simply Dashappa. Okay, how many villages? 10 villages. Then we got Vinashya Adhipati. Vinashya Adhipati. So it was the chief of 20 villages. Okay. Then we got Shatgram Adhyaksh, chief of 100 villages. And the biggest one was the Shatgram Pati, chief of 1000 villages. Okay, this is how the administration was being carried. Okay, so you can just write, I just step aside. Okay, please write everyone. Shatgram, oh sorry, the first one Gramik, that is chief of one village. Then we got Dashap, chief of 10 villages. Vinashya Adhipati, chief of 20 villages. Then we had Shatgram Adhyaksh, chief of 100 villages. And lastly, Shatgram Pati, chief of 1000 villages. Okay, so this is what the epic of Mahabharat is telling us. Okay, so what they used to do, they used to collect the local taxes and were responsible for the defense of their village as well. So they were the tax collecting body as well as they were responsible for the defense of their village as well. So they were having the dual role, collection of taxes and the defense of their concerned villages. Then moving to the next one, that is ancient period. You know, it is because we had lost the touch, we had lost the more amount of information, and we were also too much affected or impacted with the colonial rule. So because of which the glorification thing happened. Glorification specifically of the Europe and West. the areas of Europe to the west. So when it comes to greatest political philosophers and diplomats, we take the name Woodrow Wilson, okay, Winston Churchill, or the name Karl Marx, or Machiavelli, Rousseau, Hannah Arendt, etc. I'm not saying that these guys were not great enough. These guys, they gave very great theories. Okay, no doubt in that. We talk about John Locke, okay, no doubt. These guys are very fantastic. But you know, what is the logic? Even thousands of years before these guys, there was a political, social, and economic philosopher. Political, social, and economic philosopher. His name was Kautilya, or Vishnugupta. Popularly, we call him as what? Chanakya, who wrote the greatest book of this planet. Precisely one of the greatest book of this planet, that is Arthashastra, right? Arthashastra, that doesn't only deals with economics, it deals with politics, the social administration, as well as the warfare tactics. Okay, so who is he? He is Kautilya, Vishnugupta, or Chanakya. So in that Arthashastra book, as you can see, what is mentioned? Okay, the town which was referred as Pur, even your city presently could be termed as Pur. Like for example, you could be resident of Nagpur. Anyone here from a city that is, you know, having Pur word with itself? Like for example, we have got Nagpur, we have got Kanpur, we have got Bhagalpur, okay, we have got Gurdaspur, right? So Pur is the word which was mentioned, for which we have got the historical records as well. That is the book that is termed as Arthashastra, right? So anyone here from the city which is having the name Pur with itself? Okay, so you know, there are many cities or the town areas, Gurdaspur, Hoshiarpur, Nagpur, Kanpur, Bhagalpur, or maybe another areas you could be having as well, right? So Pur, that was, chief was the Nagrik. The town was referred to as the Pur, and its chief was considered as Nagrik. Today we consider Nagrik as citizen in Hindi. But according to Chanakya's Arthashastra, okay, Nagrik was the term used for the chief of the Pur, that is village. Local bodies, they were free, as you can see, how much autonomy and independence local bodies had at that time. Okay, so they were free from any sort of royal interference, right? During the Mauryan period and the post-Mauryan period too, the headman, okay, was assisted by a council of elders, continued to play a prominent role in the village life. The system continued through the Gupta period, though there were certain changes in the nomenclature, as the district official was now known as Vishyapati, and the village headman was referred to as Grampati. Okay, so the nomenclature changed, no doubt. Nomenclature changed a lot, but still there were certain things that were common. Like for example, Grampati, okay, Vishyapati, okay, these were what? The village headmans, okay, in the post-Gupta or the Gupta period. In the Mauryan period, we had got the, you know, the Gramik as well as Nagrik. But in the Gupta period, we had got the Vishyapati as well as the Grampati. Okay, so this is how the presence of local government was there. We talk about medieval period. Okay, specifically Delhi Sultanate. We talk about the medieval period, specifically the era of Delhi Sultanate. What era of Delhi Sultanate had explained us? During the Sultanate period, the Sultans of Delhi divided their kingdom into provinces called Vilayat. Now, you would be of the opinion, sir, Vilayat was a word that I heard as when we refer the foreign land. Okay, when we refer something that is of the foreign origin, that is Vilayat. Yeah, that's true. But during the Sultan period, okay, during the Sultanate period or the Delhi Sultanate period, the word Vilayat was referred to something that is the provinces of the kingdom. Okay, so remember guys, the word Vilayat. Okay, this is a value addition for you, the knowledge addition for you. Vilayat, presently we take this word to refer or mention a foreign land. But during the Delhi Sultanate, okay, from the Mamluk dynasty, that is the slave dynasty, to the Khiljis, Tughlaqs, Lodhis, okay, or even Mughals, they used to refer, not Mughals precisely, but yeah, till Lodhis, they used to refer their provinces with the local name, okay, that is Vilayat, okay. And there were some certain sort of officers, okay. What were these officers? Actually, they were the Muqaddam, who was the head of the administration, and it was Patwari. Even today in your village area or a town area, if you are, you might be having Patwari, the office of Patwari, okay, for the sake of collection of revenues, and Chaudhary for settling disputes with the help of Panch. Panch word is here, that means there was something that is Panchayat, okay. See how wordplay happens. Just a comedy thing here, okay? A matter of joke. Yep. Yes, good afternoon, guys. If I just change the spelling of punch and I write it like this, punch, you know, just for a minute, let's understand that this is written punch. So as you can see, what is the role of Chaudhary? That is settling the disputes with the help of punch. Okay, aisa punch. Just how one alphabet can change the whole meaning. Okay, Chaudhary, that is settling the disputes with the help of the punch. But what is actual word here? It is not P-U-N-C-H punch. Okay, it is P-A-N-C-H punch. Right? Okay. So remember the three major village officials. Muqaddam, that is the head of the administration. Patwari, head of the revenue collection. And Chaudhary, that is who used to work as the this mediator along with the punch, okay, to settle the disputes. Okay, right? So this is what during the medieval ages, from epic era, that is from Vedic era, to the ancient, to the medieval. Now talking about the modern or the British era. Okay. Though British, they were they were actually brutal. Okay, though the British, they were really, you know, very like fascist some of the times. They were kind of very violent and aggressive as well. But some acts during their initial ages of administration, not in the post ages, but in the initial, in the later ages, not post, sorry, in the later ages, but in the initial stages, some acts, something, okay, they have done that is quite good. Like, I appreciate a lot Lord William Bentinck and his actions, specifically, you know, his friendship and support to the great man, the father of modern India or the renaissance of modern India, that is Raja Ram Mohan Roy. Okay, his actions towards elimination, total elimination and annihilation of the so-called evil tradition of sati, restarting the widow marriages, and yes, the banning of the child marriages. So it was Lord William Bentinck who was the biggest support system of the father of modern Renaissance of India, that is Raja Ram Mohan Roy. And along with Raja Ram Mohan Roy or Lord William Bentinck, we have got some other events as well, like for example, the Woods Dispatch and the Hunter Committee, okay? Not the Hunter Commission that happened. See, there are two things, Hunter Committee and Hunter Commission. Okay, Hunter Committee was here for the sake of the growth and development of the education system of India. Hunter Commission on the other side was in the year 1990 to look after the massacre of the Jallianwala Bagh. Okay, so Hunter word could be common, but committee and commission changes, right? So we have got the Woods Dispatch, Hunter Committee, and yeah, the things that are, you know, very good from the British side. And here there are some other things as well that were quite good, like for example, the village panchayats and their autonomy. Though in the initial stages they lost their autonomy. So what it is written, under the British regime, village panchayats lost their autonomy and became weak. But it was the year 1870, the then Viceroy or the Governor General, Lord Mayo, who represented or introduced Mayo's resolution that gave much impetus to the local institutions. Okay, so that is why, okay, what we have considered, Lord Mayo 1870s, that is Lord Mayo's resolution that gave the concept of elected representatives in the urban municipalities. Remember, Lord Mayo's resolution gave what? Impetus to the elections in the local bodies, okay, specifically municipalities. Okay, then 12 years later we got 1882, that is Lord Ripon. Okay, apart from Lord Mayo, okay, we have got Lord Ripon in 1882, which provided much needed democratic framework to these institutions. Okay, so Lord Mayo, Lord Ripon, okay, they provided impetus to the local self-government in India. Then next thing, 1907, we got a royal commission established for the sake of local administration. Okay, it was termed as Royal Commission on Decentralization, and it was led by a person. His name is C.E.H. Hobhouse. Okay, in short, C.E.H. Hobhouse. Okay, 1907, Royal Commission on Decentralization. I am 100% sure these are the things very, very new to all of you, right? These are the things which you might be encountering the very first time. I am 100% sure, right? All of you, all of these things you are hearing for the first time, probably, right? As the things are not very common, but yeah, they are here. C.E.H. Hobhouse, Royal Commission, okay, he led, or he was the presiding officer of the Royal Commission on Decentralization, 1907. Okay, then the Montague-Kempsford Reforms Act of 1919 transferred the subject of local government to the domain of the provinces. So it was the act which was favoring the provisions or the elements of decentralization. Okay, from the Royal Commission to the Montague-Kempsford Reforms Act. Okay, and then come the era of independence. Okay, see, a very general question which majority of you can answer. Where was the first panchayat made in India? It was 1959, okay, 1958 or 59, in the state, royal state of Rajasthan. Okay, the state which is, you know, decorated with the royalty of the Rajput rulers, their bravery and their valor. So that very same state of Rajasthan, the Nagaur district, got its first ever elected panchayat in India. So why we are mentioning here 1992? The difference. Before 1992, panchayats used to exist in India, but they do not had any constitutional protection, as they were not mentioned in the constitution. Only one article of the constitution, that is Article 40, one of the Gandhian principles, stated the establishment of the Gram Panchayats in India. But as we know, the Part 4, that is DPSPs, as per the provisions of Article 37. They are not binding in nature to the state. They are what? Absolutely a voluntary thing, right? So Article 40 was there, but since it was a voluntary aspect, okay, so constitutional provisions were not provided much to the panchayats till 1992, only till the 73rd Constitutional Amendment Act happened. Okay, so it added Part 9 and Part 9A through the 73rd and 74th Amendments. Okay, so Articles 243 to 243 capital O was inserted inside our constitution, and a new schedule, that is Schedule 11, Article 243G, capital G, was inserted inside the constitution. That talks about the 29 functions of the Panchayati Raj institutions of the country. Okay, so simply speaking, what we have, the 73rd Constitutional Amendment Act 1992, okay, what it gave? It gave Part 9, Articles 243 to 243 capital O, okay, Schedule 11, under which we have got, okay, Article 243 capital G, okay, which talks about the 29 functions of panchayats in India. Right? So this is what 73rd Constitutional Amendment Act has given to us. Okay? So here we go. The structure of Panchayati Raj system in India. First and foremost, it talks about the Gram Sabha. Okay? We talk about the panchayats. So its biggest body is the Gram Sabha. Who all will be the members of Gram Sabha? Okay, who all will be there, who will be considered as the members of Gram Sabha? Okay, let's understand. All the adult members who are registered in the electoral roll are part of Gram Sabha. So all those village citizens, those who are 18 and above, and they have been registered into the electoral voter list, that is electoral roll, okay, they are all part of what? They are all part of the organization, that is Gram Sabha. So you can understand how big and important organization it is. If I am a resident of a village area, I am 18 and above, and I have got my name registered into the voter list as well, I am one of the members of Gram Sabha. Okay, without any registration, without any election, nomination, nothing. Just because I am the resident of a village, I'm 18 and above, and I am registered as a voter as well. That is my name into the my name is there into the voter list, that is onto the electoral roll. Now I am the part of Gram Sabha. No further registration, okay, nomination, election is required. Simply. Okay. So now, as per the provisions of the Act, okay, 73rd Amendment Act, okay, panchayats, they are to be created at the village level. Okay, panchayats, they are to be created at the intermediate level, and panchayats, they are to be created at the district level as well. Okay, now let's correlate it. Remember the provisions that Mahabharat, the epic of Mahabharat, has given us. What are those provisions? The villages, they were grouped into 10, 20, 100 and 1000, where the chief of one village was termed as Gramik, chief of 10 villages was termed as Dashap, chief of 20 villages was termed as Vinashya Adhipati, chief of 100 villages as Shat Gram Adhyaksh, and chief of 1000 villages as Shat Gram Pati. Okay, here we have got something very similar, or not similar but like that, or motivated or inspired through that grouping. Okay, that is, we have got the village level panchayat, that is panchayats at the village level. We have got the panchayat at the intermediate level, that is a group of villages, they are making a panchayat for themselves. Okay, and we have got a panchayat at the district level as well, right? So remember, panchayats, they are of 3 different tiers or 3 different levels: village, group of villages, a whole district. Okay, now there is a particular exception as well. Okay, as you can see, the exception here clearly mentions the exception, this point. However, as per the provisions of the Act, which Act? 73rd Constitutional Amendment Act, a state which is having a population less than, that is below 20 lakhs, okay, may not constitute panchayat at the intermediate level. So if there is a state in India which is having a population less than 20 lakhs, then that state is given the leniency or the type of a freedom to not create panchayat at the district, at the intermediate level. Okay, this is what is mentioned into the 73rd Constitutional Amendment Act of 1992. So let's summarize it. Panchayats at 3 levels: village, intermediate and district level. If the state is having a population less than 20 lakhs, then the state may or may not constitute the second level, that is the intermediate level of panchayats. Okay, so we talk about the composition of the panchayat. Okay, simply speaking, the composition of the Panchayati Raj institutions. So panchayat at every level, call it the village, intermediate or district, okay, consist of a chairperson and other members. The numbers, okay, of the members, that is the minimum to maximum amount of the membership, it is not fixed. Okay, it is literally not fixed. So the chairperson as well as other members of panchayats shall have the right to vote in the meetings of the panchayat, obviously. Elections, how the elections are done, let's see. Elections of the members of panchayat as well as the chairperson, how the elections they happen. So all the members, literally who? All the members of panchayats at the village, intermediate and district level shall be elected directly by the people. Here we are dealing with whom? Only and only with the word members. Okay, members at all the 3 levels, village, intermediate and district, shall be elected how? Shall be elected directly by the people. But the twist, the chairperson of panchayat at the village level shall be elected, okay, in a manner as determined by the state legislature. Then the chairperson of panchayats at the intermediate and district levels shall be elected indirectly among the elected members. So what is the catch? Firstly, just please note it down very carefully. Okay, the members, okay, the members of panchayats at all the levels at all the levels shall be elected directly. Okay, shall be elected how? Directly. The twist: the chairperson at village level shall be elected in a manner as specified by state legislature. Simply speaking, that is, if the state legislature justifies elections to be held directly, then it shall be held directly, or it may also specify that the chairperson shall be elected indirectly. Okay, so chairperson exactly at which level? Exactly at village level. Please mark the difference. Chairperson at village level only shall be elected as the manner in the manner as specified by whom? As specified by state legislature, not the central government, not the state government, even state legislature. Okay, and state legislature may say that yes, you shall be elected directly, or state legislature may say that no, you shall be elected indirectly. Okay, so it could be anything, but where the catch is for the village level only. Now, if we twist the story here, okay, if we just twist the story, so what is it telling us? Okay, so here keep this thing in mind. Now, the next big thing, okay, that is the chairperson at the intermediate and the district level shall always be elected indirectly. How? Indirectly. That is 100% but obvious justified thing. Chairperson at which level? Intermediate level. Okay, shall always be, okay, intermediate and district level. Okay, shall always be elected how? Shall always be elected indirectly. Right? So guys, please make the difference very clear in your notes. Don't get confused. UPSC plays the game of the questions and options from the very same topics. Okay? Everyone clear? Understood? Can I have the comments please from everyone? All those who are live here with me. Come on. Everyone, those who are listening live. Is this point clear? This point firstly and this point later. Firstly this one. Okay, this is what we discussed first. Okay, and the other one. That is this one. Can I have the thumbs up, please? Yes, okay. Nice. Khub bhalo dada. Okay. So this is what? The difference between the elections of the chairperson and the members at the village, intermediate and district levels. Okay. Next. Reservation of seats. Are seats reserved in panchayats? Is it so? See, when we talk about here, first of all, are seats reserved in Parliament? What is the answer? Presently, no. But as per the 106th Constitutional Amendment Act of 2024, that talks about the Nari Shakti Vandana. From the next elections, that is 2029, seats in Parliament shall be reserved for women. Okay, but it is from the time period 2029 elections, not as of now. But when we talk about reservation of seats for women as well as the other categories we have, that is scheduled castes and scheduled tribes, the seats are reserved for them in the panchayats. So as per the provisions of the 73rd Constitutional Amendment Act, okay, seats are reserved for the scheduled castes as well as tribes in every panchayat, that is at every level, from the village level to the intermediate level and to the district levels, okay, in proportion to their population in the panchayat area, right? So basically the state legislature, okay, what the act says, shall provide for the reservation of the offices of chairpersons in the panchayats at the village or any other level for the SCs as well as STs. Okay. Now remember, the reservation concept of the seats in panchayats, it is valid only up to 2030. Okay. This is what the 73rd Constitutional Amendment Act has already specified. Okay. Right, everyone? So please highlight this point. Okay. As per the provisions of the 73rd Constitutional Amendment Act. Okay. The reservation of seats for SCs and STs shall end in the year 2030. It might be extended as well, but it will be requiring a parliamentary approval. Okay, right? So here, as of now, what 73rd Amendment has said, that by the year 2030, it shall end. For panchayats as well as municipalities when it comes to the 74th Constitutional Amendment Act. So are the seats reserved for women as well? Okay. So yes, as per the provisions of the 73rd Amendment Act, okay, 33% of the seats, they are reserved for women, including the women coming from the SCs and ST categories. Okay. Along with that, the seats are reserved for the backward classes category of citizens as well. Okay, but this is a voluntary provision, not mandatory. Okay, so guys, remember, as per the provisions of the 73rd Constitutional Amendment Act, what it is saying: the seats shall be reserved for SCs and STs that shall end in the year 2030 as per the present stand. Secondly, 33% of the seats shall be reserved for women, including the women coming from the SCs and STs. Okay. No, they are not 1/3. Okay, the provision shall be as per the Delimitation Commission prescribes. Okay. So coming to the point here, reservation of seats for women, including the women coming from the SC and ST categories. Okay, that is 1/3, that is 33% of the seats. Apart from that, we have got a voluntary provision as well, that is keeping the seats reserved for the socially and educationally backward classes. Okay, that is simply the other backward classes, right? But this provision, that is keeping the seats reserved for OBCs, it is simply voluntary in nature. That is, the state legislature, as per the 73rd Constitutional Amendment Act, may reserve the seats for the OBCs, or may not even. Okay, that is why it is termed as what? It is termed as voluntary provision. Okay, so the 73rd as well as 74th, okay, the 73rd Amendment as well as 74th Amendment kept some voluntary as well as compulsory provisions. Compulsory as in jo hona hi hona, that is, they are bound to be present. Then others, we have got the voluntary provisions as well. Voluntary as in, that means you may follow or you may opt not to follow as well. That is, you may opt out of it as well. Okay, so what are the compulsory provisions? As you can see, the compulsory provisions, they include the constitution of panchayats at all the 3 levels. What it is mentioned at the top, as you can see, the compulsory provisions as in the presence of panchayats at all the 3 levels. That is district, intermediate, as well as the village. Apart from that, direct elections to all seats in panchayats. Okay, then members. Okay, members, they are always directly elected. Members, they are never indirectly elected. Only it is the chairperson who can be elected indirectly in the intermediate as well as the district level, and at the village level it is at the discretion of the state legislature. Okay, generally it is the direct elections only. Then apart from that, minimum age for contesting elections, not voting, minimum age for contesting elections, it is 21 years. Okay, in any level, village, intermediate or district. Okay, then the gram sabhas should be there mandatorily, and apart from that, the reservation of seats shall be there for SCs, STs and women. What are these provisions? These provisions are absolutely compulsory in nature. Okay, what are these provisions? Absolutely compulsory provisions. Now talking about the next thing, that is voluntary provisions. What are the voluntary provisions? One such we have already discussed, that is the keeping of the seats reserved for the backward classes, and apart from that, providing some financial autonomy and the representation of the areas of the MPs and MLAs of the area, okay, into the panchayats. It is also the voluntary provision. It is not mandatory in nature. Okay, guys. So what are the things we need to mark? Okay, the representation of the MPs and MLAs in the area, keeping the seats reserved for the backward classes, providing the greater financial autonomy, and etc. These are what? The voluntary provisions as per the 73rd Constitutional Amendment Act of 1992. Okay, right? So these are the same provisions, okay, that are common in the urban local bodies, that is the municipalities. So guys, here we enter to the next chapter here after PRIs, that is municipalities, that is the municipal organization. Okay, here we go. Just the same way, okay, just the same way as we have got panchayats, okay, we have got the urban local bodies as well that are inducted through the inside the Constitution through the 74th Constitutional Amendment Act of 1992. It added a new part, that is Part 9 capital A, from Articles 243 capital P to 243 capital ZG. Remember the article numbers, okay? The part that is Part 9 capital A, Articles 243 capital capital P to 243 ZG, capital ZG, okay? And it has added the new schedule to the Constitution, okay, that is Schedule 12, that is Article 243W, that talks about the 18 functions of the municipalities, okay? So what we can mark here, what 74th Constitutional Amendment Act of 1992 gave us. Okay, so first and foremost, Part 9 capital A, Articles 243 capital P to 243 capital ZG. Okay, then it provided Schedule 12, okay, that is Article 243 capital W. Okay, what it talks about, the 18 functions, the 18 functions of ULBs, that is basically municipalities. Okay, so these are the provisions. Okay, Part 9 capital A, that is Articles 243 capital P to 243 capital ZG. Okay, schedule, a new schedule has been added, that is Schedule 12, that is having one article in it, that is 243 capital W, okay, which talks about 18 functions of municipalities. On the contrary, if you remember, Schedule 11, Article 243 capital G was providing 29 functions, 29 different functions to panchayats, whereas Article 243 capital G, Schedule 12 is providing 18 different functions to municipalities, right? Okay, so this is what 74th Constitutional Amendment Act has added in our Constitution so far. Okay, so when we talk about their evolution, okay, when we just simply figure about their evolution. So obviously urban bodies, they are not present into the epic eras or the Vedic or the ancient or the medieval eras, but yeah, they have come into the prominence only in the modern ages. So the first one is here in the year 1688. The first municipal corporation in India was established in Madras, that is modern day Chennai. Okay, so the first municipal corporation 1688, when the city of Madras, the state of Madras simply, okay, now the city of Chennai, right? 1726, next one. Okay, municipal corporation was established in the cities of Bombay, that is now Mumbai, and Calcutta, that is now Kolkata. Okay, so remember, first one, it was Madras, 1688. Then only, as you can see, 40 years later, okay, it was in the cities of Bombay and Calcutta. Okay, right? So technically 38 years it is the gap, okay, from the first municipality to the second and third. Okay, second one same year 1726, Bombay and Calcutta. Okay, 1882, Lord Mayo's resolution. Okay, 1870, Lord Mayo's resolution provided financial decentralization to the ULBs, and 1882, Lord Ripon's resolution, which is often referred to as the Magna Carta of the local self-government. Guys, if you remember our fundamental rights class, the first marathon in which we were discussing the fundamental rights, okay, what we discussed there, the word Magna Carta, okay, Magna Carta. What is this? What is this referring actually? It is, that is, most important element of something, right? This is what Magna Carta is. Like, for example, for the first time the word Magna Carta was used in the year 1215 in England for Bill of Rights, okay, by the king, the then King of England. But here we have now used Magna Carta for multiple places, okay, in multiple places. Like here, Magna Carta of the ULBs. When we just talk about Magna Carta of local self-governments, okay, in India, is Lord Ripon's resolution of 1882 that talked about, firstly, the financial decentralization that is providing more financial autonomy to the local bodies, and talking about the direct elections, having the representatives through the direct elections, right? So this is what it is termed as the Magna Carta, that is 1882, Lord Ripon's resolution, right? Okay, so here we go. Local self-government, okay, laid the foundation for the modern framework of the local governments, and for the same reason, okay, Lord Ripon, okay, for the very same reason, Lord Ripon is called as the father of local self-government in India. And the very same commission, that is the Royal Commission on Decentralization, chaired by C.E.H. Hobhouse, okay, also talked about the urban local bodies. So it provided boost to the Panchayat system in India. So it does provided boost to the urban local bodies in India. Created in 1907 and it submitted its report in 1909. Guys, please make the time period clear, okay? 1907 Royal Commission on Decentralization was made. 1909 it submitted its report nearly 2.5 years later. Okay, so it was established in the year 1907. It submitted its report in the year 1909. The basic difference is all about. Okay, so make it clear. So yeah, same 1919 Government of India Act, okay, and then 1935 Government of India Act, and then 74th Amendment Act, okay, that is the municipalities. Now, when we talk about the types of municipalities, just the very same way, okay, just the very same way we had the levels of panchayat, that is the district level, okay, intermediate level and the village level, okay, the topmost being the district, second one intermediate, and the primary one being the village. In the very same sense, municipalities, they are also, okay, having 3 different levels, or their existence are of 3 types. Okay, what are these 3 types? Okay, first and foremost, once again, a Nagar Panchayat. The name is Nagar Panchayat. It might be, you know, called with some other names as well. Okay, it is for a transitional area. Transitional area, that is presently a rural area having good amount of growth, which is converting very soon into an urban area. Okay, which is very soon converting into an urban area. That is Nagar Panchayat. Okay, Nagar word comes in here as what? As city, right? Next, a municipal council, that is for a smaller city, a smaller urban area. And then we have got a municipal corporation for a mega city or a larger urban area. Okay, so the differences we need to mark. What are the differences? Firstly, okay, what we have got the Nagar Panchayat. Guys, please tell me if you are someone living in a town area. Okay, everyone, those who are live here with me, okay, you might be living, in case you are living in a town area, which is not exactly a rural area, not even yet an urban area. You might be having a municipality with you. Please tell me, what is municipality of your area in case you are coming from the transitional area? Known as, like for example, if I tell you about my area, so my hometown, okay, it is also a type of a transitional area. So in my area, municipality is known as Nagar Nigam. Okay, in my area, it is what we do call it as Nagar Nigam. Please tell me if someone from you, okay, those who are listening to me, you are coming from a particular area that is a transitional area, that is not even exactly a rural area, not yet an urban area. So there you would be having a municipal body. So, okay, so it is called with what name? Is it Nagar Panchayat or is it Nagar Nigam? What it is, okay? Or any other name you could be having as well, okay? So Nagar Panchayat or Nagar Nigam, for what? It is for a transitional area. Transitional area as in an area converting from rural to urban. Okay. Then next what we have got municipal council. Okay. Municipal council. It is for what? It is for a small urban area. Okay, small urban area as in a small city. A city but not very big city. It is a small city. Okay. Then we have got the third one, that is municipal corporation. Okay. What we have got? The third one, that is municipal corporation. That is for what? That is for a bigger city, or we term it as the mega city. Okay. So yes, no one from the town area or the transitional area. Okay, no problem. So guys, remember 3 types of municipality: Nagar Panchayat or Nagar Nigam. I have got one name with me. You might be having some other names with you. Okay. Then we have got municipal council or municipal corporation. Municipal council for what? For a smaller city. Municipal corporation for what? A mega city or a bigger city or a bigger urban area. Okay. Now, who will decide that this area is transitional area? How and who will be the deciding authority? So here lies the answer, that is, it will be the governor of the state. Okay, who will it be? It will be the governor of the state who has to specify a transitional area or a smaller urban area or a larger urban area. Okay, so who specify? Okay, who is the authority or the person or the power who is having the authority or the power to decide that whether this area is a smaller urban area, a mega urban area or a mega city or a transitional area? So it is the governors of the states. they do specify. So how they do specify? What are the things they do keep in the mind? Okay, so firstly, the population of the area. Secondly, the population density. Thirdly, the revenue generated by the local administration. Then the percentage of employment in non-agricultural activities. Then economic importance. And last, such other factors as he or she may deem fit. Okay, so who is the deciding authority? It is the governors of the states. And how do they decide? Firstly, what is that? The population. Secondly, the population density. Thirdly, the percentage of employment in non-agricultural activities. Okay. Fourthly, the economic importance, and lastly, okay, the revenue generation. Right. Basically, one more point is there, that is any other thing as the governor may deem fit. Okay, that's it. Right. So governor will be the deciding authority. That is, this area is the transitional area, this area is the bigger urban area, or this area is the smaller urban area. So a transitional area will be having a Nagar Panchayat or Nagar Nigam or whatever the name it could be. The smaller urban area, it will be having the municipal council, whereas the mega city or the bigger urban area will be having the municipal corporation. Okay, so just like the Panchayat, it consists of a chairperson and other members. Members, they are not fixed. Okay. Now, one extra thing, what we have here. The state legislature, the state legislature may provide for the representation of the following persons in a municipality. Okay, who are they? Persons having special knowledge or experience in municipal administration, but since they are not the members, so they do not have the right to vote in the meetings of the municipality. Then the members of the Lok Sabha and the State Legislative Assembly, this is voluntary in nature. This is what? Literally voluntary in nature. Then the members of the Rajya Sabha and the State Legislative Council, okay, those who are registered as a voter, they are also voluntary in nature. And the chairpersons of the committees other than the ward committees. So there are different types of committees inside a municipality. Okay, like for example, the committees. What are the types? So ward committees, district planning committees, or municipal planning committees. So there are three types of committees. Generally it exists. Okay, there could be a fourth one as well, any other task. Okay, so what are the types? So we have got three types basically. Okay, that is the ward committees. Then we have got the district planning committees, and we have got the municipal planning committees as well. And there could be such other types of committees, whatever is required. But generally there are only three. Okay. So the chairpersons and the members of the committees can also be represented other than ward committees. Okay. So elections. How are the elections going to happen? So the elections of chairperson and members of municipalities, all the members of municipality or urban local bodies shall be elected directly by the people of the municipal area. Okay, the chairperson or the members, they are elected directly. Okay, for this purpose, each municipal area shall be divided into the territorial constituencies to be known as the wards. Okay, so you might be having in your area the ward member, right? Okay, so they come from here. Okay, and the state legislature may provide the manner of the election of the chairperson of a municipality. Okay, so same as we discussed about the reservation of seats. So the seats shall be reserved for SCs and STs in proportion to their population. Along with that, it shall cease to exist by year 2030. And yes, the seats shall also be reserved for women. okay, 33%, that is 1/3 of the seats, okay, right? And yes, the voluntary provision here as well, the very same we discussed in panchayats, that is the seats to be reserved for the backward classes of citizens, okay? So guys, all clear? Can I have the doubts now? Please tell me if you guys are having any doubts, any questions I need to address. If there are no questions, then please do comment no question, no doubt as well. Quickly. Quick and fast, please. If no questions are there, then please do comment no questions as well to everyone who is watching online, live. No one to comment, no one to answer. Okay, fine. Okay guys, so we have got the next chapter as well, that is the center-state relations, okay? But before starting the next chapter, okay, I think I need a short break of around 10 minutes, okay? So guys, we shall resume the class. It is 5:19 now, so we shall take a break right now and we shall be back within 10 minutes, okay? And we shall resume the class, okay? So here we have got what? The break. Class resumes at 5:30 p.m. Okay, so guys, see you all in sharp 10 minutes, okay? Okay guys, welcome back. So we are good to go, right? So welcome back once again after the short break. So before going to the break, we discussed about the panchayats and municipalities in India, the Panchayati Raj institutions and the municipal bodies in India, right? So here we come to the next thing, that is the center-state relations in our country, okay? And before entering into the chapter, okay, before talking about the relationship of the center and the states, the very important thing that we need to understand about the scheme of federation in India. Okay, what is the scheme of federation in India? We have discussed this in the previous topics, okay, the previous classes we had, okay, but it's important for us to discuss it here as well, as majority of you would be watching the very first class might be, okay. So let's discuss it, okay. The Indian Federation. What is federation actually? When the different units or kingdoms, they unite together to create a bigger kingdom or a nation, it is termed as what? It is termed as federation, okay? Just in the very simplest of the form, when different units or sultanates or kingdoms, they unite together to create one single unit, one single country or a kingdom, that is termed as federation, okay? So for India, we talk about Article 1 of the Indian Constitution. What it says: India, that is Bharat, shall be the union of states. The union of states. A thing that we need to mark always, that is the word federation is nowhere mentioned in the Indian Constitution. Word federation is nowhere mentioned in the Indian Constitution. Okay, literally nowhere. Okay, we do not have the mentioning of this word, that is federation. What we have mentioned precisely the word that is union only, and not the word federation. Why? Because of this particular thing. What clearly justifies, okay? India is a federation with unitary bias. That are, we are having more tilt towards the unitary aspect. In general, okay, what India is often mentioned, okay, that is India is a country of, okay, India is what? A country of destructible states with indestructible union. Okay, destructible states with indestructible union. Okay, this is often referred to India. Okay, that in India we can, submerge the two or more states altogether, divide one state into 2, 3, 4 parts, okay, alter the names, fabricate the boundaries and so on, right? So this is what India is. So that is why we are a federation with unitary bias. Simply speaking, who are we? Okay, we are quasi-federal. So India, what are we? India is a quasi-federal state. Okay, or in India we have got the other feature as well, that is we are the cooperative federalism. Okay, we are following the principles of cooperative federalism. We are cooperative federal. Okay, so this is what we have got for India. Okay, and now the next thing. In India, here we talk about in India, the union or the center is more powerful. Okay, the union or the center is more powerful as compared to the states. Okay, generally, if geographically, okay, remember, generally, if geographically, geometrically, we represent the federalism. So we represent it through a straight line. Okay, so federalism is represented through what? Through a straight line. Okay, but the problem is in India. Okay, this is what federalism is generally referred. Okay, or something like this, or exactly like this. Not even that. Okay, this one, where the center and the states, they are sharing equal amount of powers. But this is not from the Indian context. Indian context is this. A bit of the tilt. Okay, a bit of the tilt is visible. At the top we have got the center or the union, and in below we have got the states, right? As per the provisions of Article 355, okay, what it states? It is the duty of the center to protect the states from any kind of internal disturbances or external aggression. Okay, what it is? The duty of the center to protect the states from any kind of internal disturbance or external aggression. This is what the Constitution itself mentions. That is where it is stated that in India, okay, in India, center or the union plays the role of big brother. Plays the role of what? Big brother. Okay, as when it comes to the power distribution, okay, just make this thing clear. Center plays the role of what? Big brother. Okay, as why? What are the reasons? What are the features for this particular statement? As because the power distribution in India between the center and the states is not equally done. Okay, the powers, they are not equally distributed between the center and the states. Okay, and that is why we have got this geometrical representation where center is having the upper hand or the bigger hand as compared to the states, right? Now, how we can say that generally? How we can say that? So there are multiple instances that are referred in the Constitution in only. Like for example, the Schedule 7 of the Indian Constitution, that is having one article in it, Article 246. What it talks about, that is there are legislative functions, okay, distribution of the legislative functions, right? So there are three lists: the union list, the state list, as well as the concurrent list. Okay, the three lists. Whatever items that are mentioned in the union list, only and only the union is empowered to legislate. Whatever articles are mentioned in the state list, state in general conditions, state in general conditions can make laws, but in unavoidable or non-general conditions, like for example the imposition of President's rule, or the imposition of the national emergency, or even the financial emergency, okay, the union can legislate on the state list. Okay, now comes the concurrent list. Here the union and states, they both can make laws. Who can make laws? Both, that is the union as well as the states. But let's say on one particular subject, both have them legislated, both of them have legislated. So whose law shall prevail? It will be the law of the union only. Law of the union shall prevail. Okay, in case of collision. Okay, in case the union as well as the state, they both have legislated on a particular topic that is mentioned in the concurrent list. Okay, so whose law shall prevail? Only the union law. Then there is also a residuary list. There is also mention of the residuary list. Okay, the residuary powers, like for example, as per the Government of India Act 1935, residuary powers were given to Viceroy, okay, or the Governor General, or as per the Cabinet Mission Plan, okay, as per the Cabinet Mission Plan 1946, the residuary powers were given to provinces. Okay, but all of these were changed. Okay, all of these were literally changed because as per the Constitution, as per the Constitution of India, residuary powers are given to center or the union only. Center or union only. Residuary as in that is not mentioned in either of the lists from state to union to concurrent. Okay, so it has gone a particular series of evolution, right? As per the Government of India Act 1935, residuary powers were entered into the hands of the Viceroy or the Governor General of India. Then as per the Cabinet Mission Plan of 1946, residuary powers were given to the provinces. But the Indian scheme of federation, okay, as per the Constitution of India, residuary powers, they are mentioned, they are given to whom? To the union or to the center only, right? So all of these things, they make center more powerful as compared to the states. Like for example, there are other features as well where the union is having the upper hand. Like for example, appointment of governors, okay. Then the presence of all India services, they can be done only by the center. Okay, so these are the things which represent that the union is having the upper hand, and that is why the geometrical representation comes this way. That is upper hand to the union, okay, and the dominated one, they are the states, right? So this is how the Indian scheme of federation is, and that is why this name, that is, what is India? India is a quasi-federal state, as stated by a very famous political philosopher of the time, K.C. Vere. Okay, right? So now coming to the chapter, that is the center-state relations. What are the things? So this relationship between the center and the states, okay, relationship between the center and the states, they are divided under three groups or under three headings basically. What are they? The legislative relations, the administrative relations, and the financial relations, as you can see. So how many of them? Three: legislative, administrative, and financial relations. Okay, in polity, generally, okay, after 2017 it is happening. Okay, the chapter of financial relations, it is better for you if you read it with the subject of Indian economics, Indian economy, okay, that is specifically through the chapter of GST. Okay, though yes, it's still part of the subject of polity, but I suggest you guys, that is, do not study financial relation chapter, okay, from polity perspective. It will be better if we study the chapter of financial relations from the perspective of the subject Indian economy. Okay, specifically considering the chapter of GST, the Goods and Services Tax, and the GST Council. Okay, that will provide you much better depth and analysis as well as understanding of the particular frame, that is financial relations, right? So here for our agenda, it will be the legislative relations as well as the administrative relations only. Okay, so here we start the first thing, that is the legislative relations. So the legislative relations, they are divided under multiple headings, under multiple chapters. Okay, so the first and foremost, the article numbers that deals with the chapter of legislative relations. What are they? So from articles 245 to 255, what do we have got? We have got the legislative relations that are mentioned. Okay, what articles? How many articles? From article 245 to 255. Basically, these 11 articles, they deal with the legislative relations concept. So how are legislative relations in India justified? Okay, so as what we can understand here, the territorial extent of the central and state legislation, distribution of legislative subjects, parliamentary legislation in the state field, and yes, the center's control over state legislation. So the center-state relations, center-state legislative relations. See, center-state relations, they are of three types. Okay, legislative, executive, that is administrative, as well as financial. We are dealing with the legislative relations as of now, and the legislative relations, they are divided into 4 subheading. Okay, 1, 2, 3, and 4. What are they? The territorial extent and the control of the state legislation. Okay, central and state legislation. Second, distribution of subjects in the legislative subjects in the feature. Then parliamentary legislation in the state field, and lastly we have got the centre's control over state legislation. Okay, so these are the 4 chapters or the 4 sub-classification or subdivision in the center-state legislative relations, right? Okay, so beginning with the first one, that is the territorial extent of the central and state legislation. What it is saying? As you can read the first line, the ability to pass legislation that covers, okay, ability to pass legislation that covers all or a portion of India's territory belongs to Parliament. Okay, that is, territory includes the union, states and UTs. Okay, as per part 1 of the Indian Constitution, as per Article 1 of the Indian Constitution. Okay, what is the territorial extent? From where, which part to which part, the laws of Parliament, they are applicable. So, the laws of Parliament, they are applicable throughout the whole territory of India. Okay, whereas the laws passed by state legislature are applicable to that particular state only. Okay, let's say, for example, this is the whole of India. Okay, let's say this is the whole of India. Okay, so I'm saying this is whole India, right? So a law passed by Parliament will be applicable throughout India. Okay, but here inside India we have got one state here. Okay, this is the state X, Y, Z. So a law passed by this state will be applicable to the boundaries of the state only. Okay, will be applicable to the boundaries of the state only and not outside the boundary. Okay, if there is another state here, okay, let's say if there is another state here, then the laws passed by this state will not be applicable into this state. Let's say this state, it is A, B and C. So the laws passed by the assembly of XYZ, okay, legislative assembly of XYZ, is not applicable into the areas of A, B and C. But laws passed by the Union Parliament, it is applicable throughout the territory of India. Okay, as simple as that, right? So territorial extent, what are the territorial extent? For Parliament, it is whole of the India, that is from the Indira Col to Indira Point, from Arunachal Nagaland to Gujarat Rajasthan, from Andaman Nicobar to Lakshadweep. Wherever we are saying that is it is Indian territory, laws passed by Parliament will be applicable, whereas laws passed by the state will be applicable only into that particular state only. Okay. Now here there is a particular thing that is mentioned, extraterritorial legislation. Who is having the authority to legislate laws for the territories that are not part of India? Okay, that are part of some other countries. Okay, let's say for our properties that are in any foreign soil, or the commissions or the embassies that are on any foreign soil. Who is authorized to legislate a law for any particular territory, that for a particular area which is not part of the Indian territory? Okay, that is Parliament only. So the only body with the power to pass extraterritorial legislation is what? Is the Parliament of India. Let's say for any particular area that is outside India, for example, the embassy or the High Commission or any property that we possess outside India, like for example in the Antarctica region. Okay, in the Antarctica region we have got a location where we are going ahead with the scientific research, that is Gangotri. Okay, we have got a particular location in Antarctic region. Okay, that belongs to us, that is known as Gangotri. right? So for Gangotri, who is authorized to legislate any law? Okay, that is in Antarctica. It will be only and only the Indian Parliament and not any state legislature, neither the president, neither the union government alone. It shall be the Union Parliament only, right? Next thing. This is the territorial extent. Next. Situations where parliamentary laws aren't applicable. Okay, situations where the parliamentary laws are not applicable. First, the president has the authority to enact rules that have the force and effects as same as laws passed by the parliament for the Andaman and Nicobar Islands, for the areas of the Union Territory, Daman and Diu, Dadar and Nagar Haveli, Lakshadweep and Ladakh. Okay, so in these areas, this acts passed by Parliament could not be applicable. If applicable, sorry, if applicable, then applicable with certain exceptions and modifications. Okay, in the same way, governor is entitled or empowered to direct that an act passed by Parliament does not apply to a scheduled area in the state, or if it is applied, then applied with certain or specified modifications and exceptions. Okay, who has specified this? It is the governor. Okay, so for two different locations. First location is the Union Territories of Lakshadweep, Ladakh, Andaman and Nicobar Islands. Okay, then we have got the areas of Daman and Diu and Dadar and Nagar Haveli. In these areas, President can declare that the acts passed by Parliament are not applicable, or if applicable, then with some certain exceptions and modifications. This is what the governor's power is all about. Okay, now next, President's power is all about. Next, the governor's power. A scheduled area. Okay, the acts passed by the Parliament in a scheduled area could or could not be applicable. Okay, or if applicable, then governor may specify some exceptions or modifications to that law. Okay, but only and only into a scheduled area that is mentioned inside Schedule 5 and Schedule 6. Okay, so we have got a chapter that we shall be discussing in the other marathon class. Okay, that is the scheduled and the tribal areas. Okay, the scheduled areas, that is under Schedule 5 and Schedule 6. Okay, Schedule 5 talks about the administration of scheduled areas except the states of Assam, Meghalaya, Tripura and Mizoram, whereas Schedule 6 talks about the administration of scheduled areas in the states of Assam, Meghalaya, Tripura and Mizoram. Okay, AMTM in short, right? So this is what the scheduled areas are. So the governor, who is empowered, who is entitled? The governor may say that an act passed by Parliament doesn't apply to the scheduled areas, or in case if it applies, then it applies with certain exceptions and modifications, right? So this is the areas where the Parliament's laws or statutes are not applicable. Okay. Next, distribution of legislative subjects. As we have already discussed it, okay, that is the union list, the state list and the concurrent list. There are three lists that are mentioned, okay, under Schedule 7. Okay, which one? Once again, Schedule 7, Article 246. Right, this is what is mentioned. Three lists are there: the union list, the state list and the concurrent list. Okay, in the union, only and only the union will make laws. In the state, only the states will make laws in general conditions, okay? But in unavoidable or non-general conditions, the union gets authority to legislate, and in the concurrent, they both can, okay, that is the union as well as states. But in case of collision, okay, the union law shall prevail. As well as we have got the residuary powers, but the residuary powers, they are also centered into the hands of union or the center only, okay? So, parliamentary legislation in the state field, even in non-general conditions, that is when president's rule is not even imposed, emergency is not even imposed, then also parliament can legislate for the states. And what are these conditions? Okay, so as what we can understand from here, the Constitution permits Parliament to enact laws on any topic included in the state list under the following 5 exceptional circumstances. What are they? First, when Rajya Sabha approves a resolution with the support of 2/3 of the members present and voting. Okay, that is, it is for the sake of national interest or sovereignty or internal security of the nation that the union shall legislate on a particular topic mentioned inside the state list. So, it will provide Parliament with the authority to enact legislation on a state list issue that is best for the nation. Such a resolution lasts for a year, and a resolution like this can be renewed a number of times or n number of times, okay, but not more than a year at a time. The laws passed in accordance with the resolution ceases to be in force 6 months after it was adopted. And the event of a disagreement between the state and the union legislation, the latter prevails. A state may, however, pass legislation on the same issue. Okay? So what is the first one? When Rajya Sabha passes a resolution. And what is the whole big story? Okay, let's understand it. When Rajya Sabha passes a resolution. What is this all about? Firstly, in the name of national interest, or it could be national security whatsoever. Okay. With special majority. Okay. With what? With special majority, that is 2/3 of members present and voting. Okay, 2/3 of the members present and voting, right? Rajya Sabha will pass a resolution, okay, and then the Parliament will make a law or legislate a law that is specifically mentioned in the state list. Such a law, okay, such a law can continue to be in operation. For what will be the validity of the law? Okay, simply you can write it, the validity of such law. Okay, it will be not more than 1 year. Okay, then can it be renewed? Renewal can happen, yes. How many times? N number of times. Okay. Now let's say renewal is not happening. Okay. Let's say in case Parliament has not done the renewal, after a year. Then what will happen? Okay, then in next 6 months, the law shall cease to operate. Okay, cease to operate. What does this mean? Cease to operate, that is, it shall end automatically after 6 months in case the Parliament doesn't renews it. Okay, this is what when Rajya Sabha passes a resolution, the first one. Second one, when national emergency has been declared. Okay, when a declaration of national emergency is in force, the Parliament may pass laws on any matter covered by the state list. That is, it is mentioned under Article 352. That is, whenever, okay, national emergency is going on, then in that case also it is possible chances are there that Parliament may legislate on any matter into the state list. Okay, then next comes when states, they themselves makes a request. It might happen that in the name of national interest or security, before Rajya Sabha passes a resolution, states, they themselves may go to the Parliament and may ask the Parliament that, dear Parliament, please legislate on this particular topic that is mentioned in the state list. So what is the next one? When a state makes a request to the Parliament to act on a list of issues by passing a resolution to that effect. Okay, right? Next, when precedent rule is imposed, it is mentioned specifically under Article 356. In fact, this was the question even asked, I guess, in 2018 or 19 prelims. Okay, when precedent's rule is imposed, who is authorized? So it is clearly mentioned under Article 356, Clause 2. Okay, or even under Article 365. Whenever precedent's rule is imposed in any state, the Union Parliament may suspend the state legislature and can also legislate on any topic that is mentioned in the state list. Okay. So, next one, center's control over state legislation. Okay, what we have got? Center's control over state legislation. According to the Constitution, the federal government is authorized to exercise the following influence over state legislative affairs. What are they? Specific laws established by the state legislature may be set aside by the governor for presidential consideration. Like, for example, it is also the very recent case of the governor of Tamil Nadu, that is R.N. Ravi, versus the government of Tamil Nadu led by M.K. Stalin. That is the usage of the veto powers of the governor under Article 200. Okay. So what we have? Article 200. Okay, that is the powers of governors to grant assent to the bills passed by state legislative assemblies. Okay, so whenever a bill is passed by, okay, the state legislative assembly, it is sent to the governor for the assent, okay, so that the bill is now considered as an act. What are the authorities or the powers the governors they possess? Okay, so the governor, basically they have got some veto powers, that is they may give the assent, return the bill for reconsideration, okay, withhold the assent, or withhold the bill, or transfer it to president. Okay. So what is the concept? Give the assent, that is providing the veto. Return the bill for the reconsideration, it is considered as suspensive veto, as if the bill is returned back to the governor with or without changes, then the governor will have to sign it. Withhold the assent, as in it is considered as the pocket veto, doing nothing, keeping the bill just in the pocket, taking no decision whether to grant the assent or transfer the bill. Okay, so transfer it to the president, that we call it as the transferable veto. Okay, so these are the types of powers the governors they do possess under Article 200 of the Indian Constitution. Okay, but there is a difference in the story, a catch or twist in the story again. There are certain types of bills. Okay, there are certain types of bills that governors must transfer, remember, okay, must transfer to the Honorable President. Okay. Like for example, what are these bills? A bill that is changing the interstate trade and commerce. Interstate trade and commerce. Or a type of a bill that is changing the position or powers of concerned high courts or the High Court. Okay, so these are a certain type of bills which the governors they are required to send it for the assent of the President of India mandatorily. Okay, they are required to send it to the assent of the President of India. Okay, no, they do not have the absolute veto there. Absolute veto, the governors they do not have in the context of state legislative assemblies, and neither the President she has in the context of the Union Parliament. Okay, but the President she has got the absolute veto in the context of the state legislative assemblies. Okay, right. So in that case, the governors they must take the assent of the President. Okay, so here it is mentioned. Okay, specific laws must be passed by the state legislature, must be set by the governor for the presidential consideration. Okay, then next, bills on specified subjects listed in the state list can only be filed in the state legislature with the president's prior consent. So there are some certain types of legislations that can be introduced inside the assembly only with the prior permission of the president, not even the governor. Okay, and yes, the president may ask a state to lay aside the money bills and other financial bills for his or her consideration. Okay, this time it is her consideration in the case of the financial emergency. Okay, case of what? The financial emergency. This time it is the case of her. Okay, right? So these are the areas where the Parliament having the direct interference in the state legislature. Okay, guys. So we are left with the discussion of the administrative relations with the today's topic. Okay, so we are left with now some certain smaller topics only, that is the administrative relations between the center and the states, the judiciary of the country. Okay, rest the other chapters from fundamental rights, duties, DPSPs, they have been already discussed in the previous chapters. Okay, now we are left with the major of the chapters like the Indian judiciary, the powers of the president, vice president, council of ministers, okay, and so on. So that we shall be, okay, winding up into the next week's marathon session. Okay, guys, so any doubts, any questions before ending the day, just please do let me know if you guys are having any questions. Any XYZ questions that I need to answer. Quick and fast, please. Any questions? No queries? No doubts? All clear? If everything is clear, then I do request, please do comment, no doubts or all clear, something like that. Come on, fast. I'm waiting, all of you. If there are no doubts, then do please comment no doubts as well. So hopefully no doubt. Okay? Yeah, fine. Okay, everyone. So that's it for today's marathon session. I hope it provided you good value addition in your knowledge and so on. And here, please do not forget to subscribe to our StudyIQ IAS English channel. Okay, you need to subscribe to the channel. As you know, from the weekdays to weekends, from morning 9 a.m. to night 10 p.m. Okay, the channel is continuously engaged, providing you the quality and quantity of the content every time. Okay, so from Monday to Saturday, morning 9 to night 10 p.m. and then on weekdays, on the Sundays, okay, we have got the, the marathon classes for you, right? So everyone, please do subscribe to the StudyIQ IAS English channel and never miss any kind of an update from the channel, okay? And yes, if you want to connect with me, okay, if there are any doubts of yours, you need me to consider them or address them. So we have got distinct platforms to be connected, okay? So on Instagram, you can search me with the username Praveen Mishra _2107, and on Telegram I've got a channel for you that is study_with_Praveen. So wherever you guys are comfortable in connecting, you can connect me and ping me on and let me know how I can help you, okay, how can I support you, and whatever your doubts are, okay, related to your academics obviously, and how can I address them, okay? So guys, thank you so much for watching. Please do not forget to hit the like button as well in case you like the video. Thank you. Good day. See you tomorrow morning, okay, 11:30 a.m. sharp in our The Hindu Analysis class. Okay, guys, good day. Take care. Jai Hind, Jai Bharat.